a bit more, I kindly request all the participants to mute their video and audio for better clarity. It gives me great honor to welcome all the distinguished resource persons, esteemed guests, as well as participants to the inaugural session of the National Seminar on Dimensions of Access to Justice, Challenges and the Way Forward, conducted by the Karnataka Institute for Law and Parliamentary Reform, Bengaluru, in association with Vaikunta Baliga College of Law, Udupi. We are incredibly privileged to be joined by the resource persons whose expertise will significantly enrich the seminar with profound insights and immense value.
Today, we are honored to have the presence of Professor C.S. Patil, Director, Karnataka Institute for Law and Parliamentary Reform, Bengaluru, as the inaugurator of today's program. We also have the presence of Dr. Revaya Odayar, Research Head, Karnataka Institute for Law and Parliamentary Reform, Bengaluru, and Professor Dr. Nimala Kumari K, Director, Vaikunta Baliga College of Law, Udupi. Now, I request Dr. Preeti Harishraj to escort our distinguished guests to the dais. Justice is a multifaceted concept shaped by social, technological, and legal transformation. Ensuring access to justice has become essential for fairness and equity. As challenges evolve, justice is dynamically shaped by reforms, international standards, and grassroots advocacy. This dynamic intersection of legal accountability, social inclusion, and scientific progress forms the foundation of contemporary efforts to create a more just and accessible legal system. With this vision, we have conducted today's seminar. As we embark upon this meaningful event, let us seek the blessings of Almighty. I now invite Ms. Srinidhi and team to lead us in the prayer. I kindly request everyone to raise from their seats.
चन्द्रचूड शिव शंकर पार्वती रमणा निनगे नमो नमो चन्द्रचूड शिव शंकर पार्वती रमणा निनगे नमो नमो सुंदरतर पिनाकधर हरा सुंदरतर पिनाकधर हरा गंगाधर गज चर्मांबरधर गंगाधर गज चर्मांबरधर चंद्रचूड शिव शंकर पार्वती रमणा निनगे नमो नमो चंद्रचूड शिव शंकर पार्वती रमणा निनगे नमो नमो.
Privileged to invite Dr. Revaya Odayar, Research Head, Kilpa, Bengaluru, to deliver the welcome address.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಕರ್ನಾಟಕ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆ ಹಾಗೂ ವೈಕುಂಠ ಬಾಳಿಗ ಕಾನೂನು ಕಾಲೇಜು ಈ ಎರಡು ಸಂಸ್ಥೆಗಳ ಸಹಯೋಗದಲ್ಲಿ ಒನ್ ಡೇ ನ್ಯಾಷನಲ್ ಸೆಮಿನಾರ್ ಆನ್ ಡೈಮೆನ್ಷನ್ ಆಫ್ ಆಕ್ಸೆಸ್ ಟು ಜಸ್ಟಿಸ್ ಚಾಲೆಂಜಸ್ ಆ್ಯಂಡ್ ದ ವೇ ಆಫ್ ಫಾರ್ವರ್ಡ್ ಈ ವಿಚಾರ ಸಂಕಿರಣವನ್ನು ಆಯೋಜಿಸಲಾಗಿದೆ. ಈ ವಿಚಾರ ಸಂಕಿರಣ ಉದ್ಘಾಟನೆ ಮಾಡಿಕೊಡಬೇಕು, ಕಾರ್ಯಕ್ರಮವನ್ನು ತಮ್ಮ ಮಾತುಗಳನ್ನೇ ಆರಂಭ ಆಗಬೇಕು ಅನ್ನುವ ಒಂದು ಅಭೀಪ್ಸೆಯನ್ನು ಇಟ್ಟುಕೊಂಡು ಕರ್ನಾಟಕ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆಯ ನಿರ್ದೇಶಕರನ್ನ ಈ ಇನಾಗ್ಯುರೇಷನ್ ಉದ್ಘಾಟನಾ ಕಾರ್ಯಕ್ಕೆ ನಾವು ಕೋರಿಕೊಂಡಾಗ ಅವರು ಒಪ್ಪಿಕೊಂಡಿದ್ದಾರೆ. ಆ ಪೂರ್ವದಲ್ಲಿ ನಿನ್ನೊಬ್ಬ ನಾವು ಗಣ್ಯರನ್ನು ಆಹ್ವಾನಿಸಿದ್ದೆವು. ಅವರು ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಸೂಕ್ತವಾಗಿತ್ತು. ಅನಿವಾರ್ಯ ಕಾರಣದಿಂದಾಗಿ ಮತ್ತು ನಮ್ಮ CS ಪಾಟೀಲ್ ಸರ್ ಅವರೇ ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ಮೀಡಿಯೇಷನ್ನಲ್ಲಿ ಅತಿ ಹೆಚ್ಚು ಕೆಲಸಗಳನ್ನು ಮಾಡಿದ್ದಾರೆ, ಲೇಖನ ಬರೆದಿದ್ದಾರೆ, ಪುಸ್ತಕವನ್ನು ಬರೆದಿದ್ದಾರೆ. ಇವರೇ ಉದ್ಘಾಟನೆ ಮಾಡಲಿ ಅನ್ನೋ ಒಂದು ಇಚ್ಛೆಯಿಂದ ಪ್ರೊಫೆಸರ್ CS ಪಾಟೀಲ್ ಅವರನ್ನು ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ನಾವು ಉದ್ಘಾಟನೆಗೆ ಕೋರಿದಾಗ ಅವರು ಒಪ್ಪಿಕೊಂಡಿದ್ದಾರೆ. ಸೊ ಈ ಕಾರ್ಯಕ್ರಮ ಉದ್ಘಾಟನೆ ಮಾಡಲಿಕ್ಕೆ ಆಗಮಿಸಿರುವ ಮತ್ತು ಈ ದಿನದ ಈ ವಿಚಾರ ಸಂಕಿರಣವನ್ನು ಏರ್ಪಾಡಾಗಲಿಕ್ಕೆ ಅವರು ಮೂಲ ಕಾರಣರು. ಈ ಕಾರ್ಯಕ್ರಮ ಮಾಡಲೇಬೇಕು, ಏಕೆಂದರೆ ಇತ್ತೀಚೆಗೆ ಒಂದು CPC ಅಮೆಂಡ್ಮೆಂಟು ಆಗಿತ್ತು. ರಾಷ್ಟ್ರ ಮಟ್ಟದ ಕೇಂದ್ರ ಸರ್ಕಾರದ ಕಾನೂನನ್ನು ಕರ್ನಾಟಕ ಸರ್ಕಾರ ತಿದ್ದುಪಡಿ ಮಾಡುವಂತಹ ಪ್ರಕ್ರಿಯೆ, ಆ ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ಬಹುಮುಖ್ಯವಾಗಿ ಭಾಗವಹಿಸಿ 2 ದಿನಗಳು, ಕೇವಲ 2 ದಿನಗಳಲ್ಲಿ ಆ ಒಂದು ಅದ್ಭುತಪೂರ್ಣವಾದ ತಿದ್ದುಪಡಿ ಬಿಲ್ಲನ್ನು ಮಂಡನೆ ಮಾಡಲಿಕ್ಕೆ ಮಾನ್ಯ ಈಗಿನ ಕಾನೂನು ಸಚಿವರಿಗೆ ಸಂಪೂರ್ಣವಾದ ಮಾಹಿತಿಯನ್ನು ಒದಗಿಸಿ ಅಸೆಂಬ್ಲಿ ಮತ್ತು ಕೌನ್ಸಿಲಲ್ಲಿ ಈ ಬಿಲ್ ತಿದ್ದುಪಡಿಯಾಗಿ ಪ್ರಾಜ್ಞಾ ವಲಯದಲ್ಲಿ, ಮಾಧ್ಯಮದ ವಲಯದಲ್ಲಿ ಎಲ್ಲ ಕಡೆಗೂ ಆ ತಿದ್ದುಪಡಿಗೆ ಒಂದು ಮಾನ್ಯತೆ ದೊರಕಿ ತದನಂತರ ರಾಜ್ಯಪಾಲರ ಅನುಮೋದನೆಯಾಗಿ ರಾಷ್ಟ್ರಪತಿಗಳ ಅನುಮೋದನೆಯಾಗಿ ಈಗ ಜಾರಿಯಲ್ಲಿದೆ. ಭಾರತದಲ್ಲಿಯೇ ಪ್ರಥಮ ಪ್ರಯತ್ನ ಶುರುವಾಗಿದ್ದು ಕರ್ನಾಟಕದ ಈ ಪ್ರಯತ್ನಕ್ಕೆ ತಲೆಯಲ್ಲಿ ಸೂಚನೆ ಬಂದಿದ್ದು, ಯೋಚನೆ ಬಂದಿದ್ದು ಮಾನ್ಯ ಕಾನೂನು ಸಚಿವರಿಗೆ. ಆ ಯೋಚನೆಗೆ ಅಮೂಲಾಗ್ರವಾಗಿ ತಿದ್ದುಪಡಿ ಮಾಡಲಿಕ್ಕೆ ಎಲ್ಲೆಲ್ಲಿ ಯಾವ್ಯಾವ ಅಂಶಗಳನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಬೇಕು, ಹೇಗೆ ಮಾಡಬೇಕು ಅಂತ ಇಚ್ಛೆ ಇಟ್ಕೊಂಡು ಮಾಡಿಕೊಟ್ಟವರು ಪ್ರೊಫೆಸರ್ CS ಪಾಟೀಲ್ ಸರ್ ಅವರು. ಸೊ ಆ ಕಾರಣಕ್ಕಾಗಿ ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ಅವರು ಉದ್ಘಾಟನೆ ಮಾಡಿದರೆ ಒಂದು ಅರ್ಥಪೂರ್ಣ ಇರ್ತದೆ ಅನ್ನೋ ಉದ್ದೇಶದಿಂದ ನಾವು CS ಪಾಟೀಲ್ ಅವರನ್ನು ಈ ಕಾರ್ಯಕ್ರಮ ಉದ್ಘಾಟನೆಗೆ ಕೋರಿಕೊಂಡಿದ್ದೇವೆ. ಸೊ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಅವರನ್ನು ಕರ್ನಾಟಕ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆಯಿಂದ, ವೈಕುಂಠ ಬಾಳಿಗ ಕಾನೂನು ಕಾಲೇಜಿಂದ ಮತ್ತು ತಮ್ಮೆಲ್ಲರ ವತಿಯಿಂದ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಸ್ವಾಗತ ಕೊಡ್ತಾ ಇದ್ದೇನೆ. ಸರ್, ತಮಗೆ ಸ್ವಾಗತ ಸರ್, ಸುಸ್ವಾಗತ. ಇನ್ನು ನಮ್ಮವರೇ ಆಗಿರ್ತಕ್ಕಂತಹ ನಮ್ಮ ವೈಕುಂಠ ಬಾಳಿಗ ಕಾನೂನು ಕಾಲೇಜು ಅಂದರೆ ತಕ್ಷಣಕ್ಕೆ ನೆನಪಾಗುವುದು ನಿರ್ಮಲಾ ಮೇಡಮ್ ಅವರು. ನಮ್ಮ ಕಾಸನ್ಸು ಕರ್ನಾಟಕ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆ ಆರಂಭವಾದಾಗಿನ ವರ್ಷದಿಂದ ಇವತ್ತಿನವರೆಗೂ ಅಂತಹದೇ ಸಂಪರ್ಕವನ್ನು ಇಟ್ಟುಕೊಂಡು ನಿರಂತರವಾಗಿ ನಮ್ಮ ಎಲ್ಲ ಕಾರ್ಯಕ್ರಮಗಳಿಗೆ ಅವರು ಎಸ್ ಅಂತಂದು ಆಗಮಿಸ್ತಾ ಇದ್ದಾರೆ. ನಿರ್ಮಲಾ ಕುಮಾರಿ ಮೇಡಮ್ ಅವರಿಗೆ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಸ್ವಾಗತವನ್ನು ಕೋರ್ತಾ ಇದ್ದೇನೆ ತಮ್ಮೆಲ್ಲರ ವತಿಯಿಂದ ಮತ್ತು ನನ್ನ ವೈಯಕ್ತಿಕವಾಗಿ. ಈ ದಿನದ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಅಧ್ಯಕ್ಷತೆಯನ್ನು ರಘುನಾಥ್ ಅವರು ವಹಿಸಬೇಕಂತ ಅನಿವಾರ್ಯ ಕಾರಣದಿಂದ ಆಗಿಲ್ಲ. ಅವರಿಗೂ ಕೂಡ ನಾವು ಪರೋಕ್ಷವಾಗಿ ಸ್ವಾಗತವನ್ನು 2 ಸಂಸ್ಥೆಗಳಿಂದ ಕೋರ್ತಾ ಇದ್ದೇನೆ. ರಘುನಾಥ್ ಸರ್ ಅವರಿಗೆ ಅವರ ಅನುಪಸ್ಥಿತಿಯಲ್ಲಿ ಸ್ವಾಗತ ಸರ್. ಇನ್ನು ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ನಮ್ಮ ಡೈಮೆನ್ಷನ್ಸ್ ಆಫ್ ಆಕ್ಸೆಸ್ ಟು ಜಸ್ಟಿಸ್, ಚಾಲೆಂಜಸ್ ಆ್ಯಂಡ್ ದ ವೇ ಫಾರ್ವರ್ಡ್ ಈ ವಿಚಾರ ಸಂಕಿರಣದ ಸಂಪನ್ಮೂಲ ವ್ಯಕ್ತಿಗಳಾಗಿರ್ತಕ್ಕಂತಹ ಅನೇಕ ಗಣ್ಯರು ಆಗಮಿಸಿದ್ದಾರೆ. ಅವರೆಲ್ಲರಿಗೂ ನಾನು ಗಿರೀಶ್ ಅವರಿಗೆ, ಬಾಪುಗೌಡ್ರ ಅವರಿಗೆ, ನವೀನ್ ಅವರಿಗೆ ಮತ್ತು ಪ್ರೀತಿ ಹರೀಶ್ ರಾಜ್ ಮೇಡಮ್ ಇದ್ದಾರೆ, ಜಗದೀಶ್ ಹಾಲ್ಶೆಟ್ಟಿ ಅವರು ಬರಲಿದ್ದಾರೆ, ಅನೀಶ್ ವಿ ಪಿಳ್ಳೈ, ಬಾಬುಗೌಡ ಎಸ್ ಪಾಟೀಲ್ ಸರ್ ಅವರು, TR ಮಾರುತಿ ಅವರು, ಗಿರೀಶ್ ಸರ್, ಇವರೆಲ್ಲರೂ ಈ ವಿಚಾರ ಸಂಕಿರಣದಲ್ಲಿ ಭಾಗವಹಿಸಿ ತಮ್ಮ ವಿಚಾರಗಳನ್ನು ನಮ್ಮೆಲ್ಲರಿಗೂ ಉಣಬಡಿಸಲಿದ್ದಾರೆ. ಅವರ ವಿಚಾರಗಳನ್ನ ನಾವೆಲ್ಲ ಸ್ವೀಕರಿಸೋಣ ಅಂತ ಹೇಳ್ತಾ ಈ ದಿನದ ವಿಚಾರ ಸಂಕಿರಣವನ್ನು ತಾವೆಲ್ಲರೂ ಮನದಟ್ಟು ಮಾಡಿಕೊಂಡು ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ನೀವು ಮುಂದೆ ಕಾನೂನು ತಜ್ಞರಾಗಿರ್ಬೋದು, ವಕೀಲರಾಗ್ಬೋದು, ಬೇರೆ ಬೇರೆ ಸಂಸ್ಥೆಗಳ ಕೆಲಸ ಮಾಡ್ಬೋದು. ಅಲ್ಲಿ ಈ ಮೀಡಿಯೇಷನ್ ವಿಚಾರಗಳ ಕುರಿತಾಗಿ ಕಾನೂನು ಎಲ್ಲರಿಗೂ ದೊರಕಬೇಕು, ನ್ಯಾಯ ಎಲ್ಲರಿಗೂ ದೊರಕಬೇಕು. ಅಂತಹ ಪಾತ್ರವನ್ನು ನಿರ್ವಹಿಸುವವರು ನೀವಾಗಿರ್ತೀರಿ. ಆ ಕೆಲಸವನ್ನು ತಾವು ಸಮರ್ಥವಾಗಿ ಮಾಡಿರಿ ಅಂತ ಹೇಳ್ತಾ, ಆ ಸಮರ್ಥವಾಗಿ ಮಾಡಿದಾಗ ಮಾತ್ರ ಈ ವಿಚಾರ ಸಂಕಿರಣದ ಆಯೋಜನೆ ಸಾರ್ಥಕ ಆಗ್ತದೆ. ಅದನ್ನು ತಾವೆಲ್ಲರೂ ಮಾಡಿರಿ ಅಂತ ಹೇಳ್ತಾ, ಕರ್ನಾಟಕ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆ ನಿರಂತರವಾಗಿ ಅನೇಕ ಕಾರ್ಯಕ್ರಮ ಮಾಡ್ತಾ ಬಂದಿದೆ. ಪುಸ್ತಕ ಪ್ರಕಟಣೆ ಇದೆ, ವಿಚಾರ ಸಂಕಿರಣ ಮಾಡ್ತಾ ಇದೆ, ವಿಧಾನಸಭಾ ಅಧಿವೇಶನ ಸ್ಪರ್ಧೆ ಮಾಡ್ತಾ ಇದೆ. ಅದರೆಲ್ಲ ತಾವೆಲ್ಲರೂ ಭಾಗವಹಿಸಿದ್ದೀರಿ. ಇನ್ನೂ ಹೆಚ್ಚಿನ ಕಾರ್ಯಕ್ರಮವನ್ನು ನಮ್ಮ ನಿರ್ದೇಶಕರಾಗಿರ್ತಕ್ಕಂಥ CS ಪಾಟೀಲ್ ಸರ್ ಅವರ ಮೂಲಕ ಮಾಡ್ತಾ ಇದ್ದೇವೆ. ಆ ಕಾರ್ಯಗಳಿಗೆ ತಾವೆಲ್ಲರೂ ಅಣಿಯಾಗ್ರಿ ಅಂತ ಹೇಳುತ್ತಾ ಈ ದಿನದ ಕಾರ್ಯಕ್ರಮವನ್ನು ಆಗು ಮಾಡಲಿಕ್ಕೆ ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಿರ್ತಕ್ಕಂತಹ TMA ಪೈ ಸಂಸ್ಥೆಯ ವತಿಯಿಂದ ಎಲ್ಲ ಪದಾಧಿಕಾರಿಗಳಿಗೆ ಮತ್ತು ವೈಕುಂಠ ಬಾಳಿಗ ಕಾನೂನು ಕಾಲೇಜಿನ ಎಲ್ಲ ಸಿಬ್ಬಂದಿ ವರ್ಗಕ್ಕೆ ಮತ್ತು ನನ್ನ ಮಾತು ಆಲಿಸಿದ ತಮ್ಮೆಲ್ಲರಿಗೆ ವಂದಿಸಿ ನನ್ನ ಮಾತು ಮುಗಿಸ್ತಾ ಇದ್ದೇನೆ. ಜೈ ಹಿಂದ್, ಜೈ ಕರ್ನಾಟಕ.
Thank you, sir. And we also extend a warm and cordial welcome to you. Offering a floral welcome is a gesture of our respect and regard. I now request Rohit sir to florally welcome our chief guest and inaugurator, Professor CS Patil, Director, Karnataka Institute for Law and Parliamentary Reform, Bengaluru. I now request Sureka ma'am to florally welcome Dr. Revaya Odayar, Research Head, Karnataka Institute for Law and Parliamentary Reforms, Bengaluru. I request Patricia ma'am to florally welcome Professor Dr. Nimala Kumari K, Director, Vaikunta Baliga College of Law, Udupi. Now I kindly request Srinivas sir to florally welcome Professor Dr. Anish B. Pillai, Associate Professor, School of Studies, Cochin University of Science and Technology. I now request Jaya ma'am to florally welcome Professor Dr. Babu Gowda S. Patil, Associate Professor, V.M. Salgaonkar College of Law, Goa. I now request Chaitra ma'am to florally welcome Dr. K.C. Girish, Associate Professor, KSLU, Hubballi. Thank you, dignitaries, for graciously accepting our token of regard. I now request Raksha ma'am to florally welcome Mrs. Revati Anish Pillai to this seminar. We also acknowledge the presence of Master Drupad and we welcome you all to this seminar. We are profoundly honored to have with us the inaugurator of today's national seminar, Professor C.S. Patil, Director, Karnataka Institute for Law and Parliamentary Reform, Bengaluru. I now kindly request Mr. Amoga Gadkar, Assistant Professor, Vaikunta Badiga College of Law, to formally introduce the inaugurator.
A very good morning to one and all gathered here. It is my distinct honor to introduce our esteemed dignitary for today's inaugural session, Professor Dr. C.S. Patil, who is currently serving as Director of Karnataka Institute of Law and Parliamentary Reforms, Bengaluru. Sir completed his BA from University of Mysore in 1983, BA LLB from University College of Law, Dharwad in 1986, LLM in Constitutional Law from University of Mysore in 1988, where he secured 2 gold medals. Later, Sir earned his doctorate in law from Karnataka University, Dharwad. Sir brings over 3 decades of experience in legal education and has made significant contribution in institutions such as JSS Law College, Mysore, HA Law College, Dharwad, KLE's Law College, Bangalore, University College of Law, Dharwad. Sir has also served as the Vice Chancellor of Karnataka State Law University, Hubballi, and has held key administrative roles including Dean, Member of Syndicate and Academic Council, and Director of KSLU's Law School, Hubballi. A prolific scholar, Sir has authored 1 book, edited 4 books, and published over 85 articles in reputed law journals. He has actively contributed to legislative reforms and policy making, including drafting the Karnataka State Human Rights Court Rules 2006, for which he is recognized by Government of Karnataka for his contribution in human rights. Also, Sir has served in the Committee on Reforms of Criminal Justice chaired by Honorable Dr. Justice V.S. Malaimath and Expert Committee for establishing Karnataka Rural Development and Panchayat Raj University. Beyond his academic and research contribution, Sir is deeply committed to legal literacy, legal aid, and holistic development of students, actively engaging them in academic and extracurricular activities for over 3 decades. Ladies and gentlemen, it is indeed a privilege to have him with us today. Please join me in welcoming Professor Dr. C.S. Patil, the inaugurator of today's session. Welcome, sir.
Esteemed inaugurator, Professor C.S. Patil sir, along with the dignitaries on the dais to graciously do the honors.
Shubham kurutvam kalyanam arogyam dhanasampada. Shubham kurutvam kalyanam arogyam dhanasampada. Shatru buddhi vinashaya deepajyotir namostute. Deepajyotir namostute. Deepajyotir parabrahma. Deepajyotir janardanah. Deepajyotir parabrahma. Deepajyotir janardanah. Deepo hartu me papam. Sandhya deepa namostute. O deepa brahma rupasvam. Jyotisham prabhuravyayah. O deepa brahma rupasvam. Jyotisham prabhuravyayah.
We also acknowledge the presence of Dr. Jagdish S. Halshetty, Advocate, High Court of Karnataka, Bengaluru. Sir, we welcome you to this program. I request Mr. Amok sir to florally welcome sir. It is now my honor to invite our esteemed inaugurator, Professor C.S. Patil, to deliver the inaugural address.
When we undertook an exercise in Karnataka State Law University, the exercise of mapping the non-state justice systems that are operating in Karnataka, right from the Nayaka and Gondali tribes to temple justice, Dharmasthala, church courts, Jamaat, etc., etc. One prominent contribution came from Udupi for that project. That was a study of Human Rights Protection Foundation, which is housed here in Vaikunta Baliga Law College, rendering its human service in dispensation of justice, sometimes through courts, sometimes beyond the courts. With a jurisdiction that extends far beyond the territorial borders of this country. When we conceived this idea of having a conference on access to justice, I felt there cannot be a better institution for this theme than VBCL Udupi. This is for the work that this institution has done for the cause of justice. And second reason why we always admire VBCL is because of the people who man this institution, persons who are present here in the institution, the affection, the cordiality, and more than anything, the professionalism with which they organize the programs. And that's how we have come here to be part of Vaikunta Baliga College of Law to discuss, deliberate on this very important concept, dimensions of access to justice, challenges, and the way forward. Our Honorable Minister, Shri H.K. Patil, he has a lot of respect for academicians. When he was the law minister in 2004, 2005, he involved academicians in the process of lawmaking. And later again, when he is there as law minister for the second time, again he has involved a lot of law teachers in this exercise. Why conferences and seminars like this? I tell you that great man Anna Hazare started a protest against corruption, and there was mammoth and massive support from all over the country. The whole country stood behind him. And the then government of India, it said, yes, we accept your demand. Give us the draft. We will enact it into law. There was no draft. There was one draft, and there was no way that can be accepted because it was combining both investigation and judging together, which is impossible under the present constitution. Why I give you this illustration is, when the situation comes, concepts should be ready. If there are concepts, concepts can be pressed into service. If the concepts are not ready, then we will be at blank and we will not know how to tackle that situation. What we did in COVID, heart specialist was speaking, orthopedic fellow was speaking. There was no virologist who was speaking there. And that was a pandemic wherein virologists should have played a very prominent role. And somehow God saved us. We could cope with that, and appropriate measures at the level of central government, state government, the casualty was controlled. So we should be ready. Where these concepts develop, see, these conferences, workshops, roundtables, these are the crucibles from where the concepts should evolve. At the beginning, it may be foolish. Somebody makes a point and we will say, this is highly impracticable, useless. But you have come across this statement, nobody can stop the idea of which the time has come. Each idea, it will get its time, and at that time, that idea will be translated into reality. That's why we have to have conferences and seminars. Delay in administration of justice. All those slogans, justice delayed, justice denied, justice hurried, buried, X, Y, Z, docket explosion. It will take 350 years to clear the docket, which is right now pending with the courts. So many things we have talked, spoken, written, published, wasted papers. We have criticized the judges, we have criticized the advocates, we have criticized the litigants, we have criticized the government. We have not left anybody. We have criticized everyone tooth and nail. But the question arises, I have to give full credit to our Honorable Law Minister. In one of the speeches, he was very, very vocal and vehement. Gundas are deciding disputes. Those dons. Bhai, he is deciding disputes. Especially when big money is involved, land is involved, he decides. Okay? And business sector, it has its own dispute resolution mechanism. Sindhi Panchayat is there. Maratha Mandal is there. They are resolving disputes. Rowdies. He asked one question. If justice is accessible, why they will go to a rowdy? There is a statement, silence of good people is more dangerous than violence of bad people. Because you are not performing, they are going somewhere else to get their dispute resolved. Disputes are to be resolved because disputes have a dimension of affecting the quality of life of individuals. A person in dispute will not thrive. An institution in dispute will not thrive, and a nation in dispute also cannot thrive. That's why there is a wonderful statement, not to know dispute resolution is to be functionally illiterate in society. If I want to live in this society, I should know the techniques of dispute resolution. We speak of justice. Administration of state has taken this responsibility of administering justice on its part with the adoption of the Constitution, with the bedrock of rule of law, and at an autonomous profession, advocacy, with its own autonomy of deciding who will be on the rolls, who will not be on the rolls. And they are having monopoly to espouse the causes of others. I cannot espouse the cause of others. I am not an advocate. Jagdish can do that because he is an advocate. When that autonomy is conferred, autonomy comes with greatest responsibility of auto-regulation, and professional autonomy comes with that quid pro quo, that is pro bono publico commitment. That is the profession that we have, and there is one more dimension to that, that it is an independent profession. We people in the field of law all of us are students of law. We have to understand what is our responsibility, where we stand vis-a-vis the society in which we are living, and what is the duty that we have to discharge. Dr. Nirmala, who is presiding over this program, and my colleague Revaya Vadiyar, who shares all the responsibility of organizational dimensions of our institute, and wonderful resource persons. All these resource persons together, they raised a slogan. What is the slogan? You should not speak. We are resource persons. You are a person. Okay, better you do it. You light the lamp and do the ceremonies. We have a saying, ceremonial head. Okay. And I feel so confident with the presence of these resource persons. Shri Professor Anish Pillai, we are very fresh friends, new friends, and very fast friends, because within 2 months we have caught up with each other, shared wavelength, shared commitment, shared values. That's how it happens. It is so nice to have Professor Anish here, person from Kerala. Kerala is known for qualitative legal education. And we respect the professors, academicians, and judges of Kerala always. When Anish invited me to deliver a lecture for Justice Krishna Iyer's chair, I was really scared a bit. And for us in Karnataka, it is always a privilege to publish our articles in Kerala Academy Review, Cochin University of Science and Technology, CULR, and the latest Kerala Department, Kerala University Law Journal. It is so nice that, sir, you are here with us to discuss and debate in this program. Professor Babagowda Patil is our next generation in the teaching profession, and he had the benefit of understanding how not to teach because he attended my class. So, having undergone all that punishment which you are undergoing at the hands of your teachers, so he has excelled himself well, and he has invented his own methods. In Salgaonkar College of Law, Panaji, they have done wonderful experiment, as we are proud of VBCL with its Human Rights Protection Foundation. We are proud of Salgaonkar, VM Salgaonkar also, for the legal aid, legal literacy programs that they conduct throughout the state. They have for about 70 to 80 legal aid centers permanently established in every village of Goa. And it is happening for more than a decade that they are rendering such a wonderful service. I felt I will request him also to be here with us. And you are here, Professor Babagowda. You are my strength here. And we have Professor Girish Casey, an hardcore student of constitutional law. Anytime he talks to me or talks to somebody else, he is on a point. Sometimes irritating questions. And he makes us read. And this is how we invent ideas. We invent principles and doctrines. Robert Kennedy was campaign manager for John Kennedy. He has made a statement. People look at things as they are and ask why. I look at things as they never were and ask why not. And I put Girish in that category. Girish, you are here in this program to throw light on constitutional dimensions of access to justice. That should be very great listening to you. And I have Jagdish Alshetty, a practicing advocate, a mooter of his times, carrying bags and baggages of lady councils in the team. You know, sometimes when I was the principal of a college, I used to get requests, sir, send me in any team but not with the ladies, sir. Because they have to guard, carry all that baggage, with all respect for the ladies because of their weight. Okay. So he was part of my first moot court team in University Law College, Dharwad. All the teammates have excelled very well. And we, for the first time from that college, we participated in Salgaonkar National Moot Court Competition. And I had to rely very heavily upon Jagdish when I drafted CPC Karnataka Amendment, Second Amendment, of which right now Professor Anish shared some dimension, that he has shared that Gazette notification with some of the judges there in Kerala. We don't know how successful we will be, but we have taken this step. That was the message of our law minister. He was very clear. Those commercial courts, fast-tracking system, he called me and said, we will go and sit in the commercial court and see what they are doing there. Make arrangements. Study commercial courts. He was very clear without mincing words from the public platform. He has spoken at least 3-4 times. Why there should be quick administration of justice wherever moneyed people are involved? Why the same speedy justice should not be available when poor person is involved? He said we should provide equally efficient, speedy remedy of the same quality even when poor people are involved also. Why only fast-track courts, commercial courts? Why there should not be courts, similar courts for others? Then he said, you study. Then I made a study. I have never practiced. I have not enrolled myself as an advocate. So that practical dimensions and inputs, I said, Jagdish, you come and sit with me. So we sat at a table, worked, exerted ourselves, and we have a sort of moot court team. We have some advocates in our team who always oppose what we do. There is a senior advocate by name Shrikant Karoshi. Whatever sentence we have written, he will always oppose, because we have to put it to the scrutiny. Right from Vedas, this is the culture. We have to scrutinize before we adopt. So ultimately, something happened and we prepared the draft and gave it to the department. Went before the subcommittee of the cabinet for scrutiny, approved, introduced, passed in both the houses in the Belgaum session of Karnataka legislature, went to governor, deferred for the assent of the president, and president approved. When we said CPC cannot be, CPC is a central law, state can amend it. But Karnataka has successfully carried 2 amendments to CPC, having done that first amendment wherein, a small amendment wherein it is stated that the dispute of a small farmer and a poor person, we have fixed criteria, who is a small farmer and who is a poor person. His case is to be on priority disposed of in 6 months. That is a small amendment, and that also got the assent of the president and it was notified. And our minister was very, he had a strong conviction that he will get this also through the office of the governor and president. And that happened. That way, Karnataka has taken the first dynamic and revolutionary step in the field of providing access to justice in one sense. Apart from that, there are myriad forms of providing access to justice. And we are here to explore for one simple reason. Providing justice is not a charity. Providing justice is a duty. For all of us in the field of law, professionals, it is a duty. That's why we call ourselves a profession. And we are academicians who are grooming the professionals who will walk into the field and who will be holding the floor. And there is a saying, nobody can claim monopoly over justice. Nobody can claim. Courts cannot say, I am in charge and I am the only institution who can do justice. No. Sometimes the village head may be giving better judgments than the judgments of a court, because he is not a prisoner of the rules of evidence and the procedure. He is having freedom from all these structured programs. He can do justice, and mediator will say, my institution is better, we resolve disputes in a different manner. Nobody can claim monopoly over justice is one thing. And the next question is, why all cases should go to courts? If the case is not fit to go to a court, see, that is the thing. For everything we have one formula, take it to court. Courts are not, see, what is happening in Human Rights Protection Foundation is counseling. When medical issues are involved, appropriate counseling, they have reconciled so many marriages. They have saved so many children becoming orphans. They have saved so many elderly persons, secured their food. And more than anything, that warmth and affection, they retained their relations because of this method of resolution of disputes. As students of law, it is our responsibility to be part of this system of enhancing access to justice and contribute our own bit to the resolution of disputes in an expeditious manner. Professor Raghunath, a very good friend of ours, accepted when we said, you organize the seminar on this theme. He accepted. We miss his presence here, but I place on record that he provided us all the logistics and coordinated this program with the help of the faculty members. Professor Rohit always adds grace. His presence in the institution, his amiability with the visitors is one more additional factor that attracts us to come to VBCL. And all the faculty members, they are all very young and they are excelling very well academically, completing their research programs and taking up assignments. In days to come, I hope, irrespective of who will be there in Kilpar as the director, the bond between VBCL and Kilpar will be so established as to be everlasting. Thank you very much for the opportunity. Thanks a lot.
Thank you, sir, for your inspiring words and guidance, and for reminding us that true professional autonomy comes with responsibility, and providing justice is not a charity but our duty. I now request Professor Dr. Nimala Kumari K, Director, Vaikunta Badiga College of Law, Udupi, to deliver the presidential address.
Honorable inaugurator of today's seminar, Professor Dr. C.S. Patil, Students Welfare Officer, Srimati Sureka, Staff Coordinators, Dr. Preeti Harishraj, Chaitra Kumari, Mr. Amok Gadkar, Dr. Jaimol, IQAC Coordinator, Resource Persons, Dr. Anish Pillai Sir, Dr. Babu Gowda Patil, Dr. Girish, Dr. Jagdish Hala Shetty, Dr. Revaya Vadaya Sir, my esteemed colleagues, my dear students, participants from other colleges and my dear students. Today we are conducting National Seminar on Access to Justice. Sir in his speech was telling that providing justice is not charity, but it is a duty. At the same time, I thank him why Kilpar has selected our college. He has observed 2 points. He says that one thing, integrity in the college. Second, very important thing is the existence of a non-state justice system in our college, that is Human Rights Protection Foundation, which is headed by Dr. Ravindranath Schonberg. I am quite sure that I am a person but not a resource person, so I speak a little. So in our Human Rights Protection Foundation, we follow a different method in order to lessen the burden on the judiciary. The 3 methodology is followed. Very simple it is. In those days when people used to read newspapers, our founder used to write articles in a local paper. A detailed article regarding a problem used to be published in media, in the newspaper, with a request to the readers to express their opinions. And during those days, clearly he used to write in very simple language what has to be done. And the press persons, that is Udayavani newspaper office, they used to get about 10,000 postcards where the people used to write their opinion. This should be the solution. Like that, they incited a sort of public opinion to solve the problem. The officer would come and next edition, the solution used to be given. After that, nowadays what they are doing means, they conduct, if the problem persists, or nowadays a different methodology is used, a press conference or a seminar or a public meeting will be held in the same auditorium only. The deprived or who has been deprived of the right, they will be invited here, and all the press persons will come and they will narrate their problem, and next day it will be published in the newspaper and the solution will be there. After that, another article will be published in the newspaper, Bhagyammaniಗೆ ನ್ಯಾಯ ಸಿಕ್ಕಿತು. What was the way? ತನಿಯಾ ಪೂಜಾರಿಗೆ ಪ್ರಾವಿಡೆಂಟ್ ಫಂಡ್ ಸಿಕ್ಕಿತು, ಅವನ ಕಾಂಪನ್ಸೇಷನ್ ಸಿಕ್ಕಿತು. Like that, this acted as 2 things. First one is solution, second one is information. Other people used to come. Now also, in the absence of our founder, that is the president, sir has gone to UK. Our volunteers are doing, about 17 students are there in the office. They also receive all the complaints. They try their level best. They write the letter to the government or the concerned officers, and with a note that a copy to HRPF. Immediately the work will be done. And every year, not alone from our college, some other college students come. They visit this place and they get trained. But I have heard about Goa Salgaonkar University, and sir, till this time students from other colleges used to come to visit our college. Surely sir, we will also come to Salgaonkar College to have other dimensions of providing legal aid. So that is the role of schools. Anyway, we are conducting seminar on different dimensions of access to justice. It's my pleasure that we have received 100 articles, research papers to be presented, and I wish to tell about 50 online, 50 offline, and I again welcome the students from the colleges, SDM Law College, Vivekananda College and Alvas Law College. Students have come for the offline presentation, and Bhuvana Jyoti Shirtadi College, Alva College and the Bhuvana Jyoti College from Shirtadi. This is a very brand new college. I welcome the students there and I wish you best wishes. I wish all the students who have come here best wishes, and I wish best wishes. And the students of St. Aloysius Law School are also here. I welcome you, and I wish best wishes to all the students and also for the seminar. Thank you very much.
Thank you, ma'am, for your inspiring words and valuable perspectives that have set the tone for this seminar. As a token of our appreciation and gratitude, I request Professor Dr. Nimala Kumari K. to present a memento to Professor C.S. Patil, sir. I request ma'am to kindly present a memento to Dr. Revaya Odayar. To formally express our gratitude, I kindly request Ms. Chaitra Kumari A., Assistant Professor, Vaikunta Baliga College of Law, Udupi, to deliver the vote of thanks.
I quote, "Gratitude is the fairest blossom which springs from the soul." I unquote. A very good morning to one and all present. Respected dignitaries, esteemed inviters, distinguished participants joining us both in person and online. I, Chaitra Kumari, Assistant Professor, Vaikunta Baliga College of Law, deem it as my proud privilege to extend the vote of thanks on the significant occasion of the one-day national seminar on Dimensions of Access to Justice, organized by Vaikunta Baliga College of Law in association with Kilpar, Bengaluru. First and foremost, on behalf of Vaikunta Baliga College of Law, I extend my deepest gratitude to Professor C.S. Patil, Director, Kilpar, Bengaluru, for inaugurating today's seminar with his inspiring address that has set the tone for our deliberations. Thank you, sir. My sincere thanks to Dr. Revaya Vadaya, Head of Research, Kilpar, Bengaluru, for being with us today. Thank you, sir. A special word of gratitude to Professor Dr. Nirmala Kumari K., Director of Vaikunta Baliga College of Law, Udupi, whose constant encouragement has been the driving force behind organizing this seminar. Thank you, ma'am. I would also like to extend my deep sense of gratitude to our respected principal, Professor Dr. Raghunath K.S., in his absentia, for his unwavering guidance and leadership in all our endeavors. Thank you, sir. We are deeply indebted to the resource persons of all the technical sessions and the chairpersons of the paper presentations whose scholarly contribution will make this seminar truly meaningful. Thank you, each one of you. A sincere thanks to Kilpar, Bengaluru for their valuable support and collaboration in making this academic venture possible. We remain ever grateful to our management, TMA Foundation, for their encouragement and constant support in all our initiatives. A warm note of appreciation is extended to our teaching and non-teaching staff whose dedicated efforts behind the scenes ensure the smooth conduct of this event. Thank you all. I also place on record our thanks to the paper presenters and the participants from various colleges who will surely enrich the seminar with their research insights and meaningful discussions. Thank you all. Finally, I extend a very special appreciation to VBCL students who remain the real strength of academic forums like this. Thank you, dear students. Once again, thank you one and all.
With this, we conclude our inaugural session. I thank all the dignitaries for being with us and making this inaugural session a memorable one. We shall now proceed to the technical session in 5 minutes. And welcome all the resource persons and participants who have joined through online or offline mode for this plenary session. Now we begin with technical session 1, which will be on the topic, an overview of Code of Civil Procedure, Karnataka Amendment Act 2024 by Dr. Jagdish S. Halshetty, Advocate, High Court of Karnataka, Bengaluru. I request Sureka ma'am to introduce our distinguished resource person.
Good morning, everyone. Distinguished dignitaries, resource persons, my dear beloved students. It is my privilege to introduce my own classmate, Dr. Jagdisha S. Halshetty. Halshetty born in a place that is Ilkal, Bagalakote district, in a teacher family. His parents served as teachers in government primary school at Ilkal for more than 30 years. Halshetty completed his schooling at Ilkal and completed his BA in the year 1995, and thereafter moved to Dharwad to pursue his legal education, and he has completed 3 years LLB in the University Law College at Dharwad in the year 1998. Thereafter, he moved to Mysore to pursue his master's degree in law and completed his LLM with specialization in international law from the University of Mysore in the year 2000. After completion of his master's degree in law, he was appointed as Vice Principal of KLE Societies Law College at Chikkodi, and thereafter he was transferred to KLE Societies Law College, Gadag, at Gadag in the year 2008, and later he moved to Bengaluru to practice law and joined the chambers of senior advocate Sri R.L. Patil and started practicing law. Having teaching background, he quickly learned the practical aspects of law and started independent practice from January 2010. He practices both at trial court and high court, and his main area of practice is writs, criminal appeals, family matters, and consumer law. While practicing law, he has pursued his research in the area of international human rights law and enrolled PhD and presented a thesis on the topic Domestic Application of International Human Rights, a Critical Study, for the award of PhD degree in law at University of Mysore, and he was awarded PhD in the law in the August 2013 by the same university. He is also accredited mediator, having undergone 40 hours of intense training at Indian Institute of Arbitration and Mediation, Cochin, in the year 2016. He has also undergone special training on human rights advocacy and access to justice at National Law School, India University, Bengaluru in 2013. He has also presented various research papers in the area of law at state as well as national level seminars, and he has also acted as a resource person in the area of consumer law, constitutional law, and international human rights law. Dr. Jagadish S. Halshetty, when he was a student of law, he was participated in Philip C. Jessup Moot Court competition held in Pondicherry in the year 1997. He has also participated in the Bar Council of India Moot Court competition in the year 1997 held at Panaji, Goa, and also participated at national level moot court competition organized by University Law College, Bengaluru in the year 1998. Jagadish was teaching law at KLE Society's Law College, Chikkodi, and he has organized state as well as national level moot court competitions at Chikkodi. Further, Dr. Jagadish S. Halshetty is invited to act as moot judge in the several prestigious moot court competitions, including Karnataka State Law University, Hubballi, KLE moot court competitions, and also our institution, that is Vaikunta Baliga College of Law. Dr. Jagadish Halshetty evinces a lot of interest in the moot court activities, and he has in this regard conducted training programs for the college students on mooting and advocacy skills, and even Jagadish Halshetty is having the good rapport with the college, especially in the case of moot court activities concerned. Even we do invite Jagadish Halshetty for training our students regarding mooting and advocacy skills. At present, Dr. Jagadish S. Halshetty is practicing law at High Court of Karnataka, Bengaluru. Dignitaries, students, once again, I welcome Jagadish Halshetty for this August gathering. So, sir, now I request to take over the session. Thank you.
Good morning, everyone here. At the outset, I must congratulate Kilpar and VBCL for organizing this national seminar on access to justice. Keep it simple. So, at the outset, I thank my guru, Dr. C.S. Patil, for providing me this opportunity to share my views on the new amendment to CPC by the Karnataka, and I thank principal of this institution for this opportunity. Without wasting much time on this, the introduction and all that, straight away I come to the topic. India, as Sir pointed out in the inaugural address, that the Karnataka is the first state to take this step in amending CPC in tune with commercial courts. No state has done in India. So we take pride, being Kannadigas, that we have taken such a bold step to amend the Code of Civil Procedure. Now, what is there in Commercial Courts Act? It's like a fast track court. Everything is in a timeline. You do evidence within this day, cross-examination this day, then defendant's evidence this day. Everything is under timeline. They have to finish it. So most of the commercial disputes are being decided within 6 months or 9 months, which I see in Bangalore. So in tune with that, if ordinary civil suits are to be decided, how good it is, right? It's a dream. And in Karnataka, that dream has come into reality. Now, what are the amendments that the Karnataka has made to the Code of Civil Procedure? The preamble to the amendment states that it aims to expedite civil cases disposal and reduce delays by providing one mandatory mediation, strict timelines, and procedural reforms through case management hearing. I will take you through the amendments that the Karnataka state has made. The first one is the insertion of a new section 89A, mediation and settlement. Now, this section provides that where there is no urgent interim relief has not sought for by the party, then every suit must undergo the mediation and settlement process. So one cannot file suit directly if you are not seeking urgent interim relief. If there is no IA seeking ex parte temporary injunction, then you must initiate this mediation and settlement process. That's what Section 89A provides for, which is in tune with the Commercial Courts Act. Then that is miscellaneous provision, insertion of new section. Then amendment of a first schedule, which deals with orders and rules. In Rule 1 of Order 5, providing timeline to file written statement within 120 days. This is a significant aspect insofar as reducing the delay in disposal of civil cases, because many a times what happens is the defendant used to delay the process of the court in disposal because he see to it that yes, he won't file the written statement in time, and after the court passes an order that the written statement is not filed, then he will file an application. Then it is posted for objection, then argument, then orders, then that's how it goes on, and 2-3 years passes through this process. And hence now what happens is the defendant has to file written statement within 120 days. If he doesn't file, then what happens? What happens is he forfeits his right to file a written statement. This is a very, very important point in civil dispute resolution, because if you lose your right to file a written statement, what happens is you have no say. You cannot lead evidence. You can only cross-examine the plaintiff. So in that way, this particular amendment, wherein providing a timeline within which the written statement is to be filed within 120 days, and the consequences of not filing it, wherein the defendant loses the right to file written statement, is important step in the speedy disposal of cases. Then the format it provides for. Then clause B of Rule 1 of Order 7 is substituted, making it mandatory for providing the mobile number and email ID in the plaint itself. So plaintiff, when he files suit, he has to provide his mobile number and email ID. That is mandatory now. And in case if you know mobile number and email ID of the defendant, you should also provide their mobile number and email ID too. Then Rule 2AA in Order 7, making it mandatory for plaintiff to state the details in plaint in respect of interest. If it is a suit for recovery of money, then what happens is sometimes they claim higher interest like 18%, 24%, sometimes 30%. So vaguely they claim the rate of interest in suit for recovery of money. So if you are doing so, for what reason? For what reason you are claiming such high rate of interest that you must state specifically is what the new amendment proposes. Then Order 8 in tune with Order 5 amendment that 120 days the written statement has to be filed, and the consequence is you forfeit the right to file the written statement. Then insertion of Rule 3A in Order 8 stating that denial to be in the manner provided in Rule 2, 3, 4, 5, which provides that the denial should be specific in the written statement. What is written statement? Written statement is a reply to the plaint. So when the suit is filed with the plaint, then the defendant answers to the plaint what he has got to say in response to the claims made by the plaintiff in the plaint. So if you are admitting, admit it. If you are denying, then the rule comes into picture, says what is the reason for that denial. So specific reason has to be assigned for denials. Nowadays what is happening is, whatever that is stated in plaint para 2, 3, 4, what we do is, we copy as it is and then say it false and baseless. So such thing will not happen now onwards. If you are denying it, then for what reason you are denying, that you have to explain and with your version of the new facts. That is again a significant change that the amendment has made. Then if you are not denying, right, then the such pleading is deemed to be admitted is what the amendment provides for. That is already there, but it is now making it more clear. This is again a very important amendment wherein the Rule 10 provides, Order 8, provides that no court shall provide or extend time to file written statement. Hitherto we file an application under this rule seeking the intervention of the court in extending the time for filing the written statement, but now there is an express provision saying that no court includes the Supreme Court also, no court shall allow filing of written statement beyond 120 days. So this is a very, very significant change that we have brought in tune with the Consumer Protection Act. Anybody who is practicing in consumer commissions would know that now you cannot file version, which we call version, which is written statement. In consumer commissions, whether it is district commission, state commission or national commission, right, not beyond 45 days. If within 45 days you have to file, if you do not file your version, then you forfeit that right to file version. What happens when there is no version, that is no written statement? Then you cannot lead evidence. So you cannot put forth your case. So it is in that way this amendment to this particular provision is significant in the context of access to justice, right? Justice delayed is denied. So in that sense, what the amendment proposes is bringing the disposal of civil suits in timeline. Insertion of Order 15AA. This is the heart of the amendment. New amendment 2024 to CPC, case management hearing. Now what happens in case management hearing? This is Order 15AA. Now, once the pleadings are completed, when I say pleadings are completed, that is after filing of written statement. So after filing of written statement, the judge has to notify a date for case management hearing. Now what happens in this process is that the judge fix a date for each and every stage in the suit. I will be framing issues on this day. Plaintiff will be leading evidence on this day. Defendant will be cross-examining the plaintiff witnesses on this day. Like that, he will fix a calendar for the stage, the civil disposal. So it is in that way, what happens is, the parties are aware that on this day, I am going to do this. Even the advocates are also aware that this is what he has to do on the particular day. It is in that way the amendment has amendment is providing for a speedy justice in civil cases. Substitution of proviso to order 17 in Rule 1, Sub-Rule 1, limiting the number of adjournment. Again, a significant amendment. Now we seek adjournment as per the Tariq pe Tariq. Now that is not going to happen. A maximum 3 adjournment you can seek, and that too, the duration of 3 adjournments is 30 days. When you seek adjournment, normally what happens is it will be called after 3 months, 4 months. That is not going to happen now. So the duration of the 3 adjournments should be within 30 days is what the amendment to Order 17. Then substitution of Rules 3A to 3F in Order 18, providing for filing of written submissions, that is for written arguments. So once you file written arguments, the court has power to limit the time for oral submissions, considering the nature of the cases, complexities involved in the civil disputes. Court can say you cannot go on days together in arguing the cases. What happens is they argue for 1 hour, seek an adjournment, then again they begin from the first, and then again take for 1 hour. Then that's how it is happening in civil cases. So it is in that context the amendment assumes significance. Then insertion of a new sub-rule 1C, 1D, 1E and 1F in Rule 4 in Order 18, providing for filing of affidavit evidence of witnesses simultaneously. Again, a very, very important amendment, right? So how many witnesses you are going to examine, you have to notify the court in advance. That is in the case management hearing, Order 15 AA. Plaintiff as well as the defendant, they have to provide list of witnesses, their witnesses, then they have to file affidavit evidence simultaneously. So there is no scope now to fill the lacuna. So you examine one witness as PW1, then see how it goes in the cross-examination, then bring another witness, PW2, try to fill the lacuna. That is not going to happen now. So it is in that way this amendment is also very, very important. Then another amendment in Order 19, which empowers the court to control the evidence. Because you cannot plead whatever you want, and you cannot lead the evidence whatever you wish to. So wherein the court can step in, and that is a significant power that is now given in the amendment to the court. They can control the evidence. Then insertion of a new Appendix 1A, that is the statement of truth, that now we have to file it mandatorily in the suit, saying that whatever I have stated, it is true, and I will abide by it. And if you are withdrawing it, the consequence is that you will not be permitted. You will not be permitted to rely on such a statement which you have withdrawn. So these are the amendments that the Karnataka has made to the Code of Civil Procedure. Now, whether this is going to be a reality or not, a reality check has to be made, right? We have made amendment, but how many of us know that the Karnataka government has amended the CPC in tune with the Commercial Courts Act? I understand 90% advocates, including judicial officers, they are not aware about the amendment that is brought to the CPC in Karnataka. So we need such workshops wherein we can invite advocates as well and judicial officers to know that yes, there is an amendment providing speedy justice. Now, if we examine some of the important amendments that are made to CPC. Now, Section 89A, insertion of Section 89A, which provides for the mediation process, right? If I do not seek any urgent relief, this provision makes it mandatory for me to go to mediation. Now, what happens is, though it encourages early resolution of disputes through mandatory mediation process, but sometimes what happens is, it may delay the very process of dispute resolution. Say, for example, the fact that they have come to court is that they have already tried their mechanism of resolving the dispute. Elders' intervention will always be there. So when they failed, then only they come to the court. So when there is no urgent relief, making it mandatory sometimes delay the process of the resolution of the cases. And at what stage of sending the parties to the mandatory mediation process is not stated. Right? That is also an important thing that is to be noted. That what I understand is, unless there is a plaint, unless there is a written statement on record, right, sending parties to the mediation would not help. So it is in that way the amendment should have provided at what stage precise time in which the parties should be sent to the mediation. These are the recommendations that I propose, that mandatory mediation process shall be adopted after filing of a written statement, which I have stated. Then there should be some mechanism allowing the parties to opt out of this mandatory process if both submit a joint petition that they don't want to go to mediation, they want resolution through court only. So that process should be available. Then at what time after failure of the mediation process, the case should be listed before the court within 15 days. That time limit should be stated. We need trained mediators also. When you are providing for mediation and settlement process, you need a handful of trained mediators. And the state should ensure first that they have good number of trained mediators before initiating such a mandatory process of mediation. Timeline for recording the outcome should also be specified. Then fixing a strict timeline for filing of a written statement, right? Within 120 days, written statement has to be filed. If not, you forfeit the right to file written statement. Sometimes in our system, this is a very, very harsh, especially where a situation demands that you need some documents, you file RTI application, they don't provide, then you go in appeal, you seek, and sometimes people are ignorant and they don't file, and sometimes advocates, due to the advocates' mistake also, sometimes it does happen. So at least there should be some mechanism to enable the parties to file a written statement after this 120 days. In exceptional cases, at least that power should be given to High Court or Supreme Court to enable the parties to file written statement. Right, this is the recommendation insofar as 120 days timeline for filing a written statement. Say if the party is suffering from illness, if there is medical evidence to show that he is suffering, and in such cases at least there should be some scope for filing a written statement if they need some documents from the authorities, etc. Even under those circumstances, there should be some provision is what I recommend. The reforms that are brought in pleadings, right, it is a welcoming one, wherein you make it mandatory to provide mobile and email IDs, and that would enable for the court to send the notices, summons through SMS, WhatsApp, or through email, the stages. Now it is happening. Now the amendment has made it mandatory. So we receive SMS, we receive email from the courts, what is the stage of the case. Whenever there is an adjournment, even then also now we are receiving the SMSs. When you file case, you receive SMS that such a case is filed. So that is possible only when you provide mobile phone number and email ID. So for that you need to establish a help desk which will assist the parties, especially in rural areas, right? Rural areas where the people are illiterate, and they need some technical help in this regard. I also recommend one more amendment in this regard, wherein making it mandatory for the defendant to mention mobile number as well and email ID when he files a written statement. So it should be made mandatory for the defendant to mention the mobile number and email ID, because plaintiff will not be knowing his mobile number and email ID when he is filing the plaint. So making it mandatory for the defendant to file it would enable the court to send the notices through the digital mode. This is a welcome amendment where the evasive denials, there is no possibility now. So the defendant has to explain each and every reason for his denial of the statements made in the plaint. Limiting adjournments, that is order 17. As I said, at the maximum 3 adjournments are provided, and that too within a period of 30 days. Case management hearing, as I pointed out, which is the most important amendment, which enable the court to fix a calendar for the disposal of the civil cases. And the most important amendment is that every suit should be disposed of within 24 months. That is 2 years. So if you file a suit today, the judge should see to it that, yes, it ends within 2 years. So case management hearing, he has to streamline the process in this particular 24 months period. This will also bring structure and accountability to pre-trial and trial stages, especially the partition suits that we see, right? 10 years, 15 years for disposal in partition suits, and the next generation will come and fight. That is happening. So now, if a partition suit could be disposed of within 2 years, yes, that should be fine. Recording evidence day-to-day basis or weekly basis under the case management hearing is also a welcome sign. But what happens is now there is already a pendency of cases, and now providing strict timeline, right, would put burden on the judges. So for that we need more judges, infrastructure accordingly. Unless and until we put this in place, I don't think this amendment would be in reality. So way back in 1987 itself, the Law Commission has provided that India needs more judges, right? More judges, and compared to Western countries where they have 150 judges per million, right? India has only 20 judges per million. So that is a significant change that we need in our judicial system, where we need more judges. So unless and until we provide infrastructure for this amendment to be in reality, right, the state government has to work in that direction. We need to provide training to the judges how this amendment, right, to a civil suit to be disposed of within 2 years. The judges should be trained, especially in deciding the case management hearings. Sometimes what happens is, when you provide 120 days timeline, strict timeline, right, most of the judges do list the matter after 2 months, right? Once 30 days, then after 2 months. So they think that the advocate will file within such a date the written statement. That won't happen. So it is in that context what I propose is judges should be trained to list the matter every 15 days, twice in a month, so as to put them on guard, right? The judge should caution them that, look, the timeline is nearing, you need to file 120 days, otherwise you will forfeit the right to file written statement. And the SMS should go to the party as well, that timeline is nearing, you need to file written statement. So if such measures are put in place, that would enable the judges to dispose of the cases in a speedy manner. Then penalties for non-compliance, right? If a party fails to file written statement 120 days, the result is he loses the right to file written statement. Instead of putting in place such a harsh measure, what I recommend is that, say, put some penalty, right? Caution them within 7 days. If you do not file, this is the fine. 15 days, this is the fine, right? Increase the fine so that, enable them to file written statement. Yes. I also recommended graded penalties. Then striking of pleadings, that can also be a penalty. Notify the party about the non-compliance and its consequences through SMS, WhatsApp, email before the dismissal. We do not have such a provision where false and frivolous suits are filed and defendant is made to context and spend more time and energy, money on this. And we need such a at least one provision where if the court comes to the conclusion that this particular suit is false and frivolous, right? Say for example, partition suits. I understand in majority of the cases where there is no case for partition, but still they file suit for partition so as to prevent the other party from enjoying it. They want to sell it, but the suit is pending. So for that reason, if it will go on for 10 years, 15 years, the defendant, their own relative, will not be able to sell the property, enjoy the property. So such false and frivolous suits for partition could be curtailed if there is such kind of a victim compensation provision is made. Cost reimbursement, that is not there. Actually it is there, but we don't file such a memo. So it is in that context, if there is a specific provision enabling the court to impose a heavy cost on such false and frivolous suits, that is welcome. Yes. All I already discussed. The one point that we missed in the Karnataka amendment is with respect to decrees FDP, final decree proceedings. The amendment is more focused on the disposal of suits. What happens after this suit? That we didn't touch it. So in that way, the amendment should have also focused on the post-decree proceedings, that is execution proceedings. So we need to put a timeline even for execution proceedings, 6 months or 1 year, like that. The timeline should also be provided for the final decree proceedings or execution proceedings. And for that we need to insert Order 20 Rule 6C in the Code of Civil Procedure, mandating the court to suo motu initiate execution proceedings after the decree is passed. So fix a date for listing of the case after the decree. So usually it is 90 days that limitation to file an appeal before the High Court. So it is in that way you list the matter after 91st day from the date of the decree. So there should not be any notice once again to the parties in the case. So now what happens is when you file FDP proceedings, right, execution proceedings, once again the notice has to go to the defendant, that is the judgment debtor. So by that time judgment debtor changes his residence. So his whereabouts are not known. So again you have to take 3 times notices, then paper publication, then initiate like that. So it is really problematic for the plaintiff. So it is in that context what I propose is, without further notice to the parties, the court has to list the matter, suo motu, initiate, and then complete the whole process within 6 months. Because the fruit of the decree, right, the plaintiff should enjoy in his lifetime is what the entire purpose of the amendment is. So formal application is not necessary. So that's how the court should function. And this is what the recommendation insofar as FDP is concerned. So decree execution calendar could also be provided under the case management hearing, not only for that, even for decree proceeding calendar. Yes, this is what 6C that I propose for the time-bound final decree proceedings and execution is concerned. Right. It's a landmark reform that the Karnataka government has initiated to put in place the strict timeline for disposal of the civil cases to make it a reality. Access to justice should be reality. It should not be a dream. Now, by amending the Code of Civil Procedure and to complete the whole process within 2 years, right? Right, one can only say in a seminar, but now it is a reality now. So we have such a procedure in place, and this is all with regard to the new amendment to Code of Civil Procedure by the Karnataka state. Any questions? You are welcome.
There was something called as overriding effect, where the CPC will prevail over the High Court rules, conflicting High Court rules. I may be wrong, but I think is that overriding effect would affect the so that overriding effect would affect the judiciary and the power which they carry.
This is in so far as the rule-making power of the court under section 149, 129, I'm right, 129, where the High Court is empowered to have its own procedure in disposal of the original proceedings, suit proceedings. Right? It is in that context, it is only an enabling provision, won't affect the disposal of cases. Section 158A, the amendment, it's only an enabling provision.
Jagdish, you mentioned about case management system. Is technology is being used in that? Because what happens is when 3 adjournments are provided, accordingly the case management calendar also has to change. So if it happens automatically through technology, that would be great. Any suggestions in this regard you have made?
Right. While fixing the date for each stages in the civil case under the Order 15AA, right? While fixing the dates, the judge also bear in mind that such a thing may happen. So it is in that context, it is within his discretionary power to extend the timeline for recording of plaintiff evidence, then defendant evidence, and then argument, then disposal. You suggested that there should be some some technical assistance, technology assistance. Yes, we can have that.
Because what happens, I fix the timeline and I get transferred. The new judge who comes there, he doesn't agree with the timeline. The case manager, he wants to change. Now that also has to be looked into.
I do not think that the next judge who comes and see the timeline that is fixed by his predecessor, he has to go by it, right? He cannot change. He has to go through.
See, last there was an interaction in Bangalore in Oberoi Hotel, wherein Honorable Law Minister was invited to address the technocrats and also the judges. The theme of the seminar was Administration of Justice and Technology, Meeting of Minds. And therein we have very loudly explored the possibility of pressing into service what is popular by now, artificial intelligence. So if this artificial intelligence can be integrated into the system, what Professor Baba Gowda says will be taken care of, that's one thing. And second, there is every possibility that all that mundane work, like picking up citations, references, cross-verification, verification of the documents, and say culling out the summary and substance of the documents, all this can be done by artificial intelligence, so that the judge at the prick of a mouse will get whatever material that is needed. And I had a meeting with the 3 best brains. In Bangalore, they are the people who have provided kiosks to all the airports, at least for 1/3 of the world, wherein I have given this idea to them, and it is all in very infant stage. Over a period of time, definitely the court also will come forward as to how to address this situation. We have to automate. And in some of our discussions, I have floated an idea, a very mundane idea. You are an advocate, you want an adjournment. Okay, you want a particular date, September 25th. Your opponent advocate, if he is also agreeable to September 25th, and if you can key in those dates in an algorithm, and if it can be accommodated on 25th, it will be accommodated, otherwise there will be suggestion of the other dates. The way we book our railway tickets, bus tickets, so whether seat number 10 is available, not available, then go to. So the only thing is we have to open our mind, and probably days to come are going to be excellent. Thank you.
Even now also, judges do maintain a diary, right? And they have a list of cases on such dates for plaintiff evidence, defendant evidence. When I seek a date, they will see their diary and say, no, this date is not available, I am already preoccupied with so many. Then we say that I will take a chance, kindly have it on that day. So that's how it goes. But if technology is put in place, that should be fine.
You acknowledge the fact that there's a huge pendency already. But do you think even the new cases, will we be, realistically, will we be able to follow the 2-year timeline, considering the already existing pendency?
Exactly is what I said, that we need more appointments, right? The judges should be appointed and infrastructure should be provided. Then only this new amendment will be in reality, right? The judges are already overburdened with the cases, and if they are forced to follow this timeline, right, 24 months, that too, right? Then probably a day will come where somebody will file a writ petition before the High Court and seek stay. And that probably may happen, what I am afraid.
Sir, could I ask another question?
Yes.
Sir, considering the fact that a written statement will not, plaintiff will not be able to file the written statement after 120 days, what if in the High Court his case, he loses the case? When he goes for an appeal in the Supreme Court, he will not have the same same guidelines which is happening in the Karnataka High Court, because the amendment is only effective in Karnataka, right?
Exactly, only in Karnataka.
So don't you think it is a little unfair that he gets extra time in the Supreme Court?
In other states,
yes.
In other states, Andhra Pradesh,
Yes.
Tamil Nadu, where this particular thing is not there, that's how the thing goes on, isn't it? This is a state.
It is the other way around. The advantage that a person in Karnataka gets, he is not getting. Okay. So because it is slow in Andhra Pradesh, you should not halt the process in Karnataka. That fellow should ask, go before the court and ask, look, this is what that happens in Karnataka, I also want the same expeditious remedy. See, already there was a proposal to have evening courts, and advocates in Karnataka have opposed it. The program was to work in same system, everything is same, work in 2 shifts. After 5 in the evening, there will be another judge coming over, another set of clerks, and advocates will appear, and another 5-6 hours hearing will happen. But advocates are not for it. They have passed a resolution opposing evening courts. But somewhere we have to take. Otherwise, system will rebound. Maybe the clients will dump even advocates also and go access justice straight.
Jagdish, his question was, if the matter goes to Supreme Court, the Supreme Court may allow him to file a written statement at that stage because they are not bound by the CPC amendment in Karnataka.
No, that's not so. Please see, when the case goes from Karnataka, so they have to abide by the Karnataka amendment. Whatever the rules that is existing in Karnataka state, right, the Supreme Court has to follow the amendment made in the Karnataka state if the case arose out of the Karnataka. And in motor vehicle accident cases, if the accident takes place in Maharashtra, they come and file it in Karnataka, especially in Andhra Pradesh, borderline. So they come here in Bangalore and they file motor vehicle cases because here compensation awarded is more. We have a fixed income criteria for those who fail to establish the income. The Karnataka State Legal Services Authority, they have fixed that for this age, this is the income For this age, this is the income. So it is, if they don't prove income of the deceased, then automatically the judge notes down the age of the deceased and this is the income, he fixes the compensation. Such a thing is not there in Maharashtra and Andhra Pradesh. That is the reason they come here. And moreover, the court fee. In Maharashtra, they have to pay court fee for seeking compensation, even in check bounce cases also. So for that, they come here, they file it. So such a thing is happening. Though we take the objection of jurisdiction, but in motor vehicle accident cases, wherever the defendant resides also, you can file the motor vehicle accident. They show the residence of the legal representatives of the deceased in Bangalore, somewhere like that. It's happening. But what your question is, what happens if it reaches the Supreme Court? Supreme Court has to follow the amendment. Any questions from that side?
Good morning, sir. What I understood was you suggested having, I mean, it's there that any case which does not require an immediate relief, interim relief, has to go through mediation. I believe there are 28 district mediation centers and one central mediation authority in Bangalore. Wouldn't it be a burden for the mediation centers as well? Because if there are parties that would generally want to go, I mean, like you mentioned, if they want to go to court, why send them to mediation again? It's a burden for the mediation centers as well. I would want to know your views on that.
Right. The idea behind making it mandatory for mediation and settlement process is to enable the parties to decide the dispute outside the court. So probably 2-month timeline is given for resolution of that dispute in the mediation center, only 2 months. So if that doesn't happen there, then again they have to come back to the court only. So not much time gap. So within 2 months they have to resolve or they can come back. So it's in that way. What you said is the mediation centers are overburdened, right? Again, that I suggested we need more trained mediators. So that will, yes. Even the law colleges, they can also step in this process of mediation and a settlement process through their mediation centers.
Gentlemen, the mediation provision is pressed in there for the reasons that mediation is participatory. The client will have a say there in the mediation process. And what happens in litigation is, in litigation, client is pushed out of the playground. Advocate is in charge. Client has no say. And when you go on learning more about mediation, you will understand one beautiful aspect of that. In mediation, it is a decision arrived at by the parties, acceptable to both. There will be no question of appeal. But in judgment, it is decided by a third party and imposed on somebody, and there is a winner and there is a vanquished. And when there is a winner and vanquished, that tag, what happens is, dispute will be resolved, but difference will continue. There will be no finality. So that's why whatever number of cases that can be disposed of by way of mediation, let it go, because the solution is acceptable to parties because it is their own solution. And when it comes from the judge, it may not be acceptable to one of the parties and the dispute will continue. That is the...
Good morning, sir. So, sir, my question was that when you mentioned that the 2 years gap in the property case, to be honest, the partition case. So, partition case nalli hirovaglene, what if one of the party is deceased? ಅವರೆಲ್ಲಾರ್ಸನ್ನ ತಗೊಬಂದು ಇಕ್ತಾರೆ. Am I right? So ಅವರೆಲ್ಲಾರ್ಸನ್ನ ತಗೊಬಂದು ಇತ್ತಾಗ you said that minimum 2 years ಒಳಗಡೆನೇ ಕಂಪ್ಲೀಟ್ ಆಗಬೇಕು ಅಂತ, as you mentioned. Again, when the LRs are entered into the case, again the process begins from the first.
No, at what stage, right? It commences from there only, starts from there, right? It won't commence from the fresh. Right? Say, for example, after filing of the written statement, if the defendant dies, the LRs are brought on record. So he has already filed written statement. Then the case will progress from there, from that stage.
So basically the LRs will be the person or just visible agirtare, but they will be not entirely responsible for the deceased.
They are stepped into the shoes of
Of the
defendant.
deceased,
That's
yeah. Thank you, sir.
Thank you. Thank you very much.
For insightful session on the new Karnataka amendments in the Code of Civil Procedure. Your expertise has greatly enriched our understanding of these landmark reforms and the impact on speedy justice. Thank you for taking the time to enlighten us and for making this session truly engaging and informative. I now request Surekha ma'am to present a memento as a token of our appreciation. With the next session, which will be on role of AI tools in ensuring access to justice in India by Professor Dr. Anish V. Pillai, Associate Professor, School of Legal Studies, Cochin University of Science and Technology. I request Jaya ma'am to escort the resource person to the stage and introduce him.
Good morning, everyone. It gives me immense pleasure to welcome you all to the second session of the one-day national seminar on dimensions of access to justice, challenges and a way forward, organized by Karnataka Institute for Law and Parliamentary Reform and Vaikunta Balika College of Law, Udupi. We are living in a world where technology is shaping every sector, including law and justice. The adequate integration of artificial intelligence with the law creates transformative potential. It extends to the areas of case management, legal research, and predictive analysis to improving access for marginalized communities. For example, even the Supreme Court of India has adopted Supreme Court Portal for Assistance in Court Efficiency, SUPRAS, as support and assistance in increasing court efficiency. On this note, it is my privilege to welcome our esteemed resource person for today's session, Dr. Anish V. Pillai, Assistant Professor at the School of Legal Studies, Cochin University of Science and Technology, Kochi. As an eminent scholar, academician, and a profound researcher, Sir is also holding the position of Coordinator, Justice V.R. Krishnaiyer Chair on Human Rights at his institution. Before his tenure at CUSAT, Dr. Pillai had a faculty position at Hidayatullah National Law University, Raipur, Chhattisgarh. His academic excellence has been recognized with numerous awards, including the prestigious Distinguished Young Faculty Award for the academic year 2017-18 from CUSAT. Sir has also been honored with the Professor Dr. A.T. Marcos Memorial Gold Medal for securing the first rank in LLM, alongside the K.C. Menon Memorial Gold Medal for being the best student in LLM from CUSAT. He was awarded a postdoctoral fellowship from the Mediterranean International Center for Human Rights Research, Italy, and in 2023, he was the recipient of the INSIC 2023 fellowship at the India School on Internet Governance. He has also served the position of visiting professor at the Department of Law, Dhaka International University, Bangladesh, and coordinator, Virtual Center for Research in Humanities and Social Sciences, CUSAT. He has also developed a MOOC course on consumer protection laws, which he is successfully offering as a 4-credit course to interested students. In addition, he has contributed 19 lessons to the UGC e-PG Padashala project. Dr. Anish V. Pillai has made remarkable contributions to legal scholarship through his authorship and editorial work. In addition, he has served as editor for several scholarly volumes such as Short Notes on Competition Law in India, Cyber Laws, Issues and Concerns, Shaded Justice and Rights, Secularism and Freedom of Religion, and Climate Change Laws, Issues and Perspectives. His scholarly activities extend to participation in numerous national and international conferences, workshops, and training programs. Notable among those are IUCN-funded Train the Trainers program in Colombo, the International Conference at Dhaka International University, and the International Summer School jointly organized by Cyprus University, University of Sarajevo, Brunvik Association, Turkey, etc. He has also engaged in workshops and conferences across the globe, including in the Netherlands, Israel, the USA, South Africa, Vietnam, Taiwan, Brazil, Singapore, Bangladesh, Indonesia, Sri Lanka, and more. In addition to his academic and research contributions, Dr. Pillai has rich experience in adjudicating national and international moot court competitions, such as the SETSEN International Environmental Moot Court Competitions, Philip C. Jessop International Law Moot Court Competition and International Criminal Court Moot Court Competition, etc. He has also crafted moot court problems in areas such as competition law, consumer law, international law, environmental law, and human rights for various national level competitions in India. With this brief introduction, I cordially invite Dr. Anish V. Pillai to address us. Welcome you, sir.
എല്ലാവർക്കും നമസ്കാരം. It's a proud privilege to stand in front of academic luminaries like Professor Patil sir and other Maruti sir, Babu Gowda sir, etc. So thank you Vaikunta Balika Law College, College of Law for inviting me to speak few words about artificial intelligence and access to justice. Well, we are all living in this year of artificial intelligence. Most of us are using ChatGPT and other AI tools, maybe for our academic purpose or for our entertainment purpose. Now, I will tell you how these AI tools or artificial intelligence can help in securing access to justice in our country. Well, before starting with artificial intelligence, I want to just highlight what is access to justice. We know already, everybody know, we are all studying law, we are all doing something or other way. But what is exactly access to justice? There are two components. One is access. Access means justice should be accessible to all, irrespective of any barrier, be it poor, be it educated, be it illiterate, etc., etc., etc. Secondly, there has to be justice. Justice means whoever is accessing it, they should get justice. Rather than mere law in the mere paper, it should be made available to them. Whatever rights, whatever interest, etc. are protected, they should feel that they are receiving it. So when we talk access to justice, this is what we meant. Now in this context, how artificial intelligence can interfere? That is what my point. Well, I would say there are 5 areas or 5 ways through which AI can ensure or speed up or interfere with access to justice. The first method is with respect to victims or injured persons. Secondly, through enforcement agencies. Thirdly, through lawyers, then courts and judges, then finally legislatures. So through these ways, in a collective way, AI can do wonder to access to justice. When we say access to justice, it is not simply approaching the court and getting remedies through court. No, that is not access to justice alone. Access to justice means, or it should include, to prevent violations of law, to prevent reaching these disputes to the court and going through all the hurdles and finally securing justice. So, access to justice, through the help of AI, we can cover up all dimensions of access to justice, rather than going through the tedious court proceedings and ending up with a remedy. Though you are the winner, you may not enjoy the benefit of that remedy. So this is what access to justice artificial intelligence can interfere with, and how they can do it. Let me explain. Starting with victims or injured persons. Now, as Patil sir observed in his inaugural address, whenever a matter comes, whenever a violation happens, immediately we will approach the court. Now, if we successfully integrate AI in our justice delivery system, we can weed out large number of disputes from reaching to the court. And that is one of the best way to avoid the long pendency and long, long block of cases. So this is one of the best way. If we use AI, the victims and the injured persons, before going to the court, before going to the lawyers seeking an advice, use an AI tool, an appropriate AI tool. describe his problems, and seek advice from that AI tool, sometimes he will stop his further proceedings there itself. Because he knows what would be his fortune if he goes to the court, even after 10 years, what he is going to receive. If the victims or the clients are aware of this initially, and that itself will reduce the overburdening of court. So that way, victims can, by themselves, before reaching to the lawyer, before reaching to the court, they will come to know what would be the fortune of their case. So they can decide initially itself. Then, filing complaints. In most of the cases, like consumer commissions and other tribunals, we used to say lawyers are not necessary. But in practice, in consumer commission, one can approach only with the help of lawyers. The reason is how to file a complaint and what format has to be followed. No, nobody knows. Even we, the law students, we also don't know. Now, if you use appropriate AI tools, it will allow you to draft your petition yourself. You give the details, like what you are using in ChatGPT for writing your assignment. You give the content, ask the ChatGPT or any other appropriate tool to create a petition for filing before the District Consumer Commission. That will give you the appropriate format. And they will tell you what are the points you have to add in that and how to craft it more effectively so that the judges will get convinced from your pleadings. So that way, AI will help victims. Again, language and accessibility. Now, we know in a country like India, we have multiple language. Even in different states, they have different languages. And most of our court documents, especially Supreme Court judgments, are available either in English or in Hindi. Now, the regional people, they may be not able to get connection with that language. So they can use AI tools. Simply ask AI tool, use appropriate AI tool. They will tell you what are the recent Supreme Court judgments on this point. And when you are apprehending, when you are suffering a problem, you just narrate that problem to the AI tool. AI tool will tell you, these are the recent Supreme Court judgments. These are the position. And by learning that, you can think whether to file your case or not. So that is the benefit of AI tools for victims, rather than misled by some lawyers. Not everyone, but some lawyers. Now, coming to enforcement agencies, especially police and other investigating agencies. Whenever a case is being filed, they will immediately start investigation in a conventional manner. Now, if they use AI tool, if we have appropriate AI tool, while receiving a petition, the enforcement agency or the investigating officer can himself identify what are the legal points involved, what are the previous cases, what is the present position, is there any interpretation given by the court recently, or some other practices being followed in other high courts. All details will come to investigating officer. Then he can investigate this matter with more effectively. And quickly he can respond to that complaint. So that way, investigating agency can very well use AI technologies, so that it will leads to ultimately access to justice. Again, in most of the criminal cases, very well-known criminal cases, we will see there are so many hue and cries. Every media will discuss, for a long days they will discuss, they will conduct discussions. At the end of the day, the accused will be acquitted. The reason is the evidence. Sometimes the evidence is missing, or the lawyers or the prosecution is not able to convince the judges clearly. Now, while investigating, the investigating officer can think about that aspect. Whatever evidences I am collecting, whatever statements I am receiving, is it sufficient to lead to a conviction? Is it sufficient or not? And what are the veracity of these issues? So all these things can be cross-checked by investigating agency before the trial begins. And if investigating agency uses this appropriately, we can ensure that in main cases or in reasonable cases, the conviction will be ensured. So that is another advantage, and that will also ensure justice to the victims, especially in criminal case. Then speeding up investigation. Most of the cases, investigating officer may wait for some documents, some accused, and the interesting fact, investigation may be done by an officer who is not well known to the court proceedings. They are very excellent officers in investigation, but they are not that much well known in investigation, in court proceedings, and they always seek advice from the public prosecutor or the Director General of Prosecution. Now, if they use an AI tool, an appropriately designed AI tool, they themselves can verify this matter, and thereby they can conduct their investigation in a very speedy and smooth manner, and which will leads to a result, which will ensure justice to the victims. Then lawyers. Now, there are so many lawyers, they are all well known. They are reading day to day the law reports and the latest developments. Now, when a client approaches a lawyer, he will narrate his problem. This is what my problem I am facing. I need a solution to this. Now, the same narration, if the lawyer, with the help of an AI tool, analyze, within seconds, he will get a result. What will happen to this case if I will go with a civil case? If I will go with another forum, what would be the end? What is the present existing law in this regard? So, as far as a lawyer is concerned, very easily, after listening the narration of the client, he can predict this is what is going to happen in the court. And it may take minimum this many years from the previous experience, because this AI tool will tell you this is the way in which this case will go, and this much time it will take in the lower court, and this much time it may take in the high court. So the timeline also you can explain to the client. So there are two things in that. One, the client will be happy because he knows, okay, this is what is going to happen, and he can take a decision whether to continue or not. And see, when you start a case, if the lawyer advises you this is what is the end result, in most of the cases you may withdraw from the filing the case. And what generally happens in nowadays, when you approach a lawyer will say, we will see. There are 50-50 chance. Then you will think, okay, we will take that 50 chance. So this is the issue. But using these AI tools, you can take a very good decision. And even lawyer can also. Sometimes in civil cases, why this delay happens? One of the reason for delay is amendment in pleadings. There are so many occasions they will keep on amend pleadings. Now, before filing this case, if they take the help of AI tools, this amendment issue can be avoided. Because the AI tool will tell you, these are the points missing in your pleadings. You will have to add in that. So before filing, the lawyer will come to know about what are the shortcomings involved in his pleadings. The same way, the opposite lawyer also will come to know. So this amendment option can be avoided. And because of that, lot of time can be saved. And the interesting thing, when we say providing justice, it is not a justice after 7 years. It should be speedy. Because the delayed justice is not justice. That is what we always believe. So this type of process will speed up the justice delivery system. Then comes the judges. This is another component which will immensely benefit the clients and the lawyers and the entire society. Whenever a case is coming before the court, now there are several courts, they are in the process of creating customized AI tools. In fact, in our Kerala state, our Kerala High Court has constituted a committee for developing an AI customized tool for the purpose of identifying which are the cases which needs immediate attention. Now, there are large number of cases, large number of writ petitions are filed. Now, judges now technically by reading each case, they are identifying this is the case which needs to be finalized at the earliest. But there may be cases, it will not create any trouble even after some time if get it delayed. Now, if you create appropriate AI tools in that way, they can identify which are the cases which needs high priority and which should be settled at the earliest. And even if there is a delay, sometimes some cases will not cause any injustice. So it can be segregated. So accordingly, the judges can chart their function and they can list the cases. So thereby it will help judges. Again, when a judge is deciding a case, now we know they are very well learned, they know each and every case, whatever is decided, but still it will take lot of time for them to read, because they will read each and every time when they want to decide or write a judgment, they will keep on read the judgments. Now you know, in our country there are judgments which is spanning over 350 page, 300 page, 200 page, 150 page. Now how much time this judge will take to write a judgment after referring all these pages? Now instead of that, if you develop an appropriate AI tool, within seconds it will generate a summary of that judgment. Even if it is 400 page, 300 page, 200 page, within seconds. Now, instead of reading each and every books, just by one click, you will get what are the previous cases. What are the correct precedents over this. So this way, judges can write their judgment very easily. Within an hour, they will be able to decide the case. Now, I have seen during my practice time, the judges will declare in the open court, this is the judgment. But they will give the copy after 2 months. The judgment you will get only after 2 months or 3 months. Why this delay? The reason is they will take time to read. So now, if we use this, then and there they can declare, this is the judgment, take it and go. And that will speed up the judge's job also. So as far as a client is concerned, once the case is filed, if judges are also using this, very easily it will come. The judgment will come very easily. Then e-courts and virtual hearings. That is another possibility. In fact, in Kerala, our Kerala High Court has started one e-court exclusively for 138 NI cases, check bounce cases. Now, in the district of Kollam, even if you want to file a case on 138 check bounce case, you have to file only through online. No need to use any paper. No need to go to any place. Everything is online. Everything is online. Judges will sit in their chamber. Clients will sit in their chamber. Lawyers will sit in their chamber. Completely online. Now, we can utilize, with the help of AI tools, we can have e-court systems. Now the timing, there is no need of time. Whenever the clients are ready, whenever the victims are ready, whenever the witnesses are ready, we can fix it. Because most of the time, the witness presence is required for examination. Now witness may be busy with some other thing. He may have job, he may not be able to turn up. So in such a situation, if we create this system, some appropriate AI tools, with that we can establish e-witness examination. Now, if he want to schedule at the midnight, let it happen in the midnight. It will be like augmented reality. We can create virtual avatars. Like I am examining a witness as a prosecutor. Now my opponent, defense counsel, will stand there as a virtual avatar. And it may have, both of them will interact maybe in a gap of 2 days or 3 days. But at the same time, we will be able to see in an interface. So that way, if we think, we can avoid lot of problems, lot of delays. Again, there are so many witnesses, they may be working in some other state, some other country, and coming back to this state and giving evidence or deposition, it's very tedious process for them, and that will also take lot of time. But using this e-reality or virtual reality, with the help of AI tools, we can sort out this problem. Thereby we can speed up the justice. Then transparency. Now, as of now, we have some system like you can track online. There are online mechanisms available. Every high court will provide what is the case status. But if we establish an appropriate AI tool, by using your mobile, every client can see what is the status of his case. No need to go and ask the lawyer. No need to go and visit every time. Just use your mobile, you will get a username and password, entire documents, entire data, everything is there in your mobile. How wonderful it is. Because I have seen several clients, they will file case and then they will come and ask us some doubts. Now then I will ask, where is the copy of the case? No, I don't have the copy. Without copy, how we will say something? They know they have filed a case, that's it. Now, instead of that, if you have a system, you just install in your mobile and you will be able to see everything directly, what is happening in the court. So you will not be misled by anybody. And you can keep going behind your lawyer. So that lawyer will settle the matter very fast. So this way, the integration of AI tools will help providing access to justice. Now, coming to the last part, the legislatures and policymakers. Now see, most of the delay happening in our court is simply because of the complexity in the law, the legal provisions. And interestingly, there are some legislations like tax, etc., corporate law subjects. Even a lawyer will take time to understand what they meant by that. The language is such complex. Then what about the clients? They don't know anything about, they can't understand. They know reading, but they can't understand anything. Now, with the help of AI tools, if the legislature appropriately makes legislations, anybody can understand. They can make these provisions very simple rather than making it complex. And they can make sure that this legislation will not go waste, because they will take lot of time to enact, for discussion, for modification, then finally it will be enacted. Then it will be challenged before the court. And ultimately court will declare it as unconstitutional. How much time they will waste? Now, if they use a proper AI tool, before it reaches to the court as a constitutional challenge, the legislature can make sure that, yes, our whatever sentence we have crafted is not against the constitutional provisions. So it will pass the test of the constitutionality. How wonderful it is. Again, it will predict. AI can predict what advantage this provisions is going to give and what the society will benefit, how the society will be benefited, how it can be made more beautiful, more oriented to the society. So this way, while formulating a policy or legislative framework, the legislature will also take the benefit. Now, in altogether, all these 5 components, I can tell you, if they use successfully AI tools, it will definitely ensure access to justice. Because as I said, access to justice is not just getting a remedy through the court of law, but all these processes considered as a component of access to justice. It's a sum total of all these components. Now, just quickly I will tell you how all this, as a summary, victims gain awareness, empowerment and easier complaint mechanisms as a victim part. AI enhances investigating agency by making them faster, smarter and more capable of handling complex crimes. Lawyers receive efficient tools for research, drafting and client management. Judges and courts benefit from case management, backlog reduction and decision support systems. Finally, legislatures are equipped with data-driven insights for better policy making. Having said all these good about AI and its integration in a justice delivery system for access to justice, I have some criticism. When we talk about access to justice, we always think about the poor people, the illiterate people, the marginalized people. Because in everywhere, wherever a discussion happens with respect to access to justice, the focus is illiterate, poor and marginalized people. Unfortunately or fortunately, AI tools are now, as of now, favoring only educated, techno-savvy and moneyed class. Because AI tools are not accessible to the downtrodden, poor and marginalized section. So because of that, to what extent AI tools can help directly to a poor, marginalized or uneducated victim is a question. So I have some critics or critical approach over this AI tools and its integration. Digital divide and unequal access. That is one of the point I want to tell you. If you use AI tools everywhere, it will be like privatization of justice. Those who are having money, they will be able to gather or get the benefit. And those who are poor and downtrodden or not techno-savvy, they will go down. Then urban bias. There are large number of sections, still we are in the villages and they are not even aware of internet and computer and how to use it and how they will take the benefit. So it is more urban bias is there. Then, so it will always widening the justice gap, making legal remedies more accessible to the wealthy and tech savvy, while the disadvantaged are excluded. That is my major criticism. Secondly, accuracy and quality concerns. Now, I said, with the help of AI tools, you can predict the outcome of your case. Now, the question is whether this AI tool is accurate or a quality one. As of now, we don't have a mechanism to check the quality or accuracy. Even ChatGPT you are all using. The 80% of response they are giving is wrong, completely wrong. If you ask it to give some data, they will give only wrong data only. Because nobody is checking the response of ChatGPT is accurate or quality one. Now the same problem will happen with when we integrating or when we developing AI tools. So if we establish a mechanism to check its accuracy and quality, and once it passes the quality test, then it is fine. But I think it's very difficult. It's not that easy. So you can consider it as an assistant, as an advisor, but not as an abstract advice. So that there is a possibility of error in prediction, biased data, like whenever you are creating an AI tool, it is always depend upon, it is working based on the data you have given for training. Now, if I am the creator of an AI tool, whatever data I will give, I may have some personal bias. So my data is also like that. And the tool which I am creating will have that bias. So that is also possible. Then absence of humanism and emotions. Now we know there are several occasions. Judges are also fond of emotions. We always hear the famous statement, when emotions comes to the court, the justice will fly through the window. Now when it comes to AI tools, only justice will be there, no emotions. Now how these emotions will disappear? I will just give you one simple example. There was a famous case in our place wherein a father, he murdered a person. A person murdered another person in point blank by shooting inside the court vicinity. Now it's a cold-blooded murder. So obviously he will get a very good punishment. It's a murder. No doubt in that. Now why he committed this murder? This accused was involved in raping and killing his daughter. So this father did this crime. Now the question is, what punishment will be given to him? There was a huge discussion. They said, everyone, entire public was saying he should be acquitted. He should not be punished. Now what the judge will do? Because he committed murder, all the ingredients of murder is there. Whether the reason for committing this murder can be taken into account. Now the judge has awarded only 5-year imprisonment, not more than that. But if the same happens with an AI tool, I am doubtful whether they will take care of these emotions. So that's why the accuracy and quality, that is also a problem. So with this, I would like to conclude. If you have any question, I will be happy to answer. Thank you for this opportunity and thank you for your patient listening.
Professor, compliments to you for the wonderful presentation.
Thank you, sir.
You have made. And personally, I am benefited to a very great extent. And the association will continue. Maybe I will be discussing with you to explore the dimensions that you have come out with in detail. Definitely yours are very wonderful ideas for the contemporary society to be very seriously taken and thought in terms of translating them into reality. And I feel very happy that these youngsters, it is a very simple fact, you are going to enter this world, and if you are not alert to pick up things, oldies like me will beat you black and blue in technology. Okay, be careful about the things that are developing, and each idea is worth to be seriously considered and experimented. Thank you very much, sir. I am benefited. Compliments to you.
Thank you, sir. Thank you.
Good afternoon, sir.
Yeah.
So, since you told that in rural areas we cannot ensure justice through the rural people, you know, in the older times there was panchayat and they used to discuss these things and all. So, what do I feel? Is there any quiet opportunities to educate them about these things? Because the common people, especially most of the people try to educate in this, but they don't get opportunities due to financial problems and these things. But what if we could take one step further, and by inspecting it, that who are interested, let we train them, and we'll install the e-courts in rural areas itself.
Yes.
What do I feel? So that in rural people they cannot be manipulated as such. One thing. Second thing, as you told that emotional judges are very much attached to it. What about the AI and the real judge work hand in hand and promote the justice by saying that if suppose this AI chat has been initiated by giving the summary of the judgment.
Yes.
But what if the real judge give the real judgment? Because robotics cannot rule the nation itself, right? Ultimately, it is the human consciousness and the humanity that matters. So what if the robotics give the draft of it by saying that this is the case, since I heard this, now it is your turn. So what about the real judge give its real judgment? That's what I feel, sir.
Yeah. So two things. One is regarding the rural people. Well, we have large number of organizations, legal aid clinics, etc. They can take the lead role because they are aware of AI and how AI tools can be used. Educating everyone in the rural area is not possible. I don't think it's not a big task, but it will take lot of time. Rather, what we can do, we can try for that. Along with that, the lead role can be taken by legal aid clinics and other NGOs, etc., working in that field. They can use this AI tools. Like, I'll tell you one example. We had a National Law University in Kochi. What they have done, they have adopted one village as a part of their legal aid clinic. And they are providing all support to that people in that village. So whenever a dispute arises, they will immediately approach them. And these people will settle that as far as possible. Very rarely the matter will go to the court. So that is also one way. So such type of agencies can use the AI tools. Now secondly, the judges. What he was saying, the robot is hearing everything, then judge is taking up. I'll give you one simple example. You are writing everything with the help of ChatGPT. So you got an assignment with ChatGPT. Now you are going to write by yourself. Then you will compare it. And you will add the missing points in ChatGPT. Then you will present it. That is an excellent way, no doubt in that. But it will take a lot of time. You will think, if I can do it by myself, by checking everything, every legislation, every precedent, why I will look at ChatGPT? Why we are taking ChatGPT? To avoid this process. Now, at the same time, you can use ChatGPT as well as all AI tools as an assistant. Like in court, judges uses assistants for drafting their notes. Like judgments, they will simply dictate, somebody will type. So same way they can do, they can just speak, that AI tool will type it, their judgment. Not asking AI to write by itself after analyzing everything. You dictate, they will type it. You can avoid one steno there. So that way, AI tools can be incorporated as an assistant. Now, I wanted the cases from 1950 to 1970s. 2015 cases I want. Instead of asking my research assistant to go and search and find out the cases, I can ask my chatbot. Find out the cases decided from this period to this period. They will give a list. I will read out and make notes. So that way, you can use the tools for assisting the judges. But you cannot replace at any cost. If you replace, there is all chance of error and quality issues. I hope I answered your problem. Yes. Yes, please.
When we talk in the phone with the AI itself, it just starts to type itself. But what I feel is when we make the AI to do everything, we are taking the employment of the other person, right?
That's a wonderful argument. When this computer was introduced, you might be heard about a story. One point of time in US, there was a mass protest by Marx teachers, mathematics professors. Why they protested? For the introduction against calculator. They said, if you introduce calculator, this mathematics will go underway. The mathematics professors were in the street. They were protested for several years against calculator. The same way when we introduced computer, there were large scale protests. And I heard that the first computer came to our Calcutta port through ship. And because of the protest, nobody was there to unload it. So it kept in the ship for a long time. Now, what is actually happening? When you are creating chatbot, there is another employment. A new sector is being started. You need somebody to make chatbot. You need somebody to maintain it, somebody to operate it. So the nature of job will change, not it will lose. Maybe you will call it as like info park and techno parks. One point of time this computer was introduced, everybody was apprehended. We are going to lose our job. Now what is happening? New profession came. New name came. So it's not the loss of job, it is the change of job. And the generation is changing. So it has to change. Like one point of time we had STD booths. Now we don't have STD booth. What these people are doing, those who are running STD booth at that time, they might have converted to SIM selling shop or mobile accessories shop. That's it. Their next generation started with that. So that's all. So it's not losing something, but it's a change. That is what development. So we have to develop. Correct. Yes. Thank you.
First of all, thank you for providing the useful insights of technology. In the concept of AI for lawyers, if the prediction of the final decision of the case is done before, it's like questioning the ability of a lawyer. There might be a 50-50, as you said, there might be a 50-50 chance. But at the end, it might change for a 90% and a 10%. So if the decision was given prior, it might be a wrong or a errorical decision.
Correct. That is true. See, there are scenarios, there are certain cases, the result is known the first day itself. Once you start practicing in the court, especially in civil cases, the first day when the client narrates the issue, the lawyer knows whether they will win this case or not. Senior lawyers, they will say, we will win this case, irrespective of anything, because the case is in favor of us. Now, sometimes lawyer will say, we are not going to win this case. But if I will say, I will not file this case because you won't win, what you will do? You will go to another lawyer. I will lose you. And the client will not be happy. So because of that, most of the lawyers knowingly, that is, I will lose this case or we will lose this case, still they will accept. Because client satisfaction is something different. When you are getting injured, when your legal right is violated, whether you will get a remedy or not, you want to file a case immediately. That mental satisfaction will be satisfied there. And after 2 years, 3 years, you yourself will feel somehow it will end. That's it. No need of any remedy. Got it. Now, secondly, there are certain cases. There 50-50 chances is there. Now, AI will also tell you the same. There are cases, positive responses have came. There are cases, negative also there. Which one is there? You can choose. That is your option. So client will get an idea. Okay, there are some cases in Orissa and etc. in favor of, but in Kerala it is in a different way. So what I would do? So it is all client's choice then. So the thing is, you will be well informed about it. Right? Like when you are joining in a course, if you have been advised after doing this course, you can reach up to this place. You will get a decision. You can make an informed decision. And at the time of joining, nobody is telling you where you will reach at the end. What you will do? The same way. Okay, yeah. Yes.
Good afternoon, sir. Thank you for the really resourceful presentation. So my question is about accountability. Say, for example, now I'm doing an assignment with ChatGPT. I'm a student and I should know the mistakes that are there in my assignment. Now, if I'm completely illiterate and I'm doing that, who will be accountable? I'm asking this in accordance to legal field.
See, the point is, when you are using any AI tool, there is a disclaimer. If you read the last part of that AI tool, there is a disclaimer, including ChatGPT. They will say, whatever we are giving is only a model. This is not an answer. Like, when you are asking AI to write a particular essay, AI will give you a model essay, not the essay. All the AI tools are giving model only. It is your duty to make your assignment in that model. Then you cannot say AI misled you. AI just said, like, see, if you want to know that today itself you write a literature review. Give any topic and ask AI to create a literature review. You will get 10 books and 10 articles. It's only a model. There may not be such article at all. But still they will give an literature review. The thing is, it's a model. Giving an example to you. That's it. So if anything goes wrong, you will be liable. See, ignorance is not an excuse. That's the only answer we can say. Because you are depending on something. Like when you are writing an article on any topic, you will take AI to, first paragraph you will ask AI to write. Now AI will tell some legislation and everything. That legislation may not be in India. It may be some other country's legislation. But they will say according to Indian so and so, so and so. Now when you submit the same, your teacher will catch. It's your fault, not AI's fault. AI is telling you can write an article like this way. So use that method only, that model only. Then you will be liable. Clear? Yes.
Good afternoon, sir. Sir.
Yes, go ahead.
Sir, in one of the report, AI system trained on Indian legal data to predict the bail decision shows 23.7% of fairness gap between Hindus and Muslim accused persons.
Mm-hmm.
So in a country like India, so the religious matters holds the sensitive role. So what is your opinion on this, sir?
See, that's what I said. It's all about bias. When I am creating an AI tool, my AI tool will function based on the data I had given. The data I had given as input for training it. Now, which type of data I will take? That's the question. If I am a non-believer of God, my data will be in that way only. If I am an ardent believer of God, my data will influence in that way. So the result will also in that way only. So that is what I said, there is no quality check. You have number of AI tools. The response or the outcome, whether it is true or false, whether it contains bias or not, nobody knows. But maybe if this development will continue, after some time there will be some mechanism to check the quality. And again, which company is creating this AI tool? That will also matters. Those who are using Grok or DeepSeek and ChatGPT, use the same keyword in these three AI tools. See the response how you are getting. Why this difference? The difference is based on the input, based on the data they had given for training it. So same way, whoever is making this AI tool, that will differ. And we cannot say it is wrong or bad. It is my AI tool. My AI tool will have my nature, my character. That's it.
So you mean the Indian legal data has been like given the wrong information for the...
Obviously. You cannot depend any AI tool. It will give always wrong data only. I would say 80% wrong data. 80%. Now what can be done? Like our High Court, they have constituted a committee to create AI tools for segregate notion of cases. Like which case to be decided first. like that. So they are creating. And once they create, they will conduct some pilot study. They will test again and again and again the quality of the output. If the pilot study is successful, then only they will incorporate. Otherwise, they will throw away that. So likewise, when we are incorporating an AI tool, we have to make sure that the responses are correct. Then we have to use it ultimately. Otherwise, we will also go in wrong way or misled by this AI tool.
Okay, thank you, sir.
Good afternoon, sir.
Yes.
As we all know, India is a very linguistic country. So, as you mentioned, AI will help in translating.
Yeah, exactly.
So, as per my knowledge, AI can only translate up to 50 or 55 languages. Then how do you tell that it can help in translating language?
Simple. Use Google Translator. That is working based on AI. It will translate into Malayalam or any language in Kannada, Hindi, Andhra, any language you will get. The problem is how accurate it is.
Yes.
How accurate it is. For that purpose, now most of the courts, high courts, are developing their own system. Like Kerala High Court, they have developed a system wherein their judgments are bilingual now. Last 3 months back, they introduced that system. Whenever they will deliver a judgment, you will have English judgment, that is a normal one, and Malayalam. Court itself is providing, and that is accurate. So after some time, see, there are techno-savvy people in every region, every language. They will create their own AI tools. Now I think Google translation is somewhat very good. Even Quillbot is there. You can use Quillbot. That will translate very nicely. But there are some errors. After some time, it will be very perfect. Because we are in the starting point only, in fact. It will take its own time. So all these possibilities will be explored by our techno-savvy people. No doubt in that. Even now, you have some apps are available. It will translate very exactly. Even typing. You type it in English, they will translate in your language. There are so many softwares are available now. Maybe it is paid now, but after some time, with the help of AI, it will be free. So wait for some time, it will happen.
Thank you for the privilege.
Yeah.
Good afternoon, sir. So my question is, as you told now itself, that AI is not providing exact answer, that 80% of the answer is almost wrong, according to you, as you told.
Yes.
So as the topic of your presentation is itself the access to justice.
Yes.
So how we can understand this, AI is giving 80% of wrong answer, and how we can get justice? The first question. Second question is that, as I saw your presentation, in that there are different aspects, as you explained. The question is that now as a law students, and we are living as a generation of Gen Z or Gen Alpha, we don't have that idea of researching to the books. So if possible, you give some idea that like which chat GPT, which AI tool is very much prompt in giving legal aids, legal solutions. If that is done, then it is better, I think so.
Yes. See, the first thing. So the first thing is regarding the access to justice, whether this is providing accuracy. Now see, these are all the potential we can explore in AI. I'm not saying our AI tools are developed in such a way to provide these benefits. But the present developments will continue for some time. Because in almost everywhere, the courts are trying to create their own AI tools. So after some time, whatever benefits I have said, that will happen. That will become a reality with utmost quality. Now, second point is regarding access to exam or access to do research. Which AI tool you can use? I would say there is no AI tool which will help you. Being students of law and potential lawyers, I will tell you, don't use AI in your class time, in your legal education time, because that will that will destroy your intellectual creativity. Nowadays, I have seen my students, for replying an email, they will take the help of ChatGPT. The problem is, one day, if you don't have access to ChatGPT or internet access, how you will write something? You will lose your intellectual creativity. I was wondering, I was just sharing with my teacher also, when I was doing my LLM dissertation, we don't have internet. We don't have computer typing. We used to write with hand. And whatever we will write from reading the books. So we had that intellectual creative capacity. Now, my students, what they are doing, whatever title I will tell, within half an hour they will come with answer with the help of ChatGPT. That means they don't have any intellectual capacity. They have that, but they are not training it. They are not using it. Now, I will advise you, if you use AI tools, you will also use that capacity. Even though you have good brain, but you won't train your brain. Because LLB time and practicing time as a junior lawyer, that is a learning stage. That is a training stage for your brain. But if you are not properly training, you will be handicapped one day. Handicapped in the sense, through intellectual creativity, you will miss out. And another problem I will tell you, that is the most serious problem. When you are submitting a draft with the help of ChatGPT, the teachers, the lawyers, the judges, they know this is created through ChatGPT. Very easily they can make out. Without using any plagiarism software. By just one reading, first sentence itself, we can make out you have used ChatGPT. And there are some smart students, they will humanize it. There are some tools to humanize AI. Now, even after 100% humanizing, reading your sentence, we will make out this is created through ChatGPT. The moment we will see that, we will disqualify your paper or your research into 0. That's it. Now, when we use some plagiarism software like Drillbit or Turnitin, we will see 20% or 15% AI plagiarism. We will accept it. Only 20%. Okay, fine. But if you humanize it, what this plagiarism software will do, they will provide a star instead of the percentage of plagiarism. If you see the star, your paper is 0. It's cancelled. The same thing will happen when you submit this to court also. Like nowadays, when you file a case, you will put your draft in the box of Shirastadar or the court officer. Now, when you submit something through online, the court officer may conduct some plagiarism check. If he found out plagiarism check, your plaint will be returned, gone. What you will do? Or you don't know how to write by yourself. You will face lot of trouble. So I will tell you during your LLB time and as a junior lawyer, don't look at ChatGPT. Generate and train your brain for original thinking and creative writing. That will help you. That will last along with you. Okay. Yes. One last question, I think. Right? Yeah. Last question.
Good morning.
We have lot.
Good morning. Good afternoon, sir. So as of now, you said a lot of pros for the useful of AI.
Yes.
On the other hand, there are some cons. In the e-courts, as you said, the virtual hearings, there will be the loss of personal interaction between the clients and the attorneys, as it is the crucial aspect of legal representation. What are your views or opinion?
See, it's not personal interaction is missing. The personal interaction, there are lot many increase in personal interactions. Like with the help of AI, we can create avatars. Like lawyer may be attending in the court, but I can talk with my lawyer just in front of me in the screen. So it will give more opportunity to interact. Otherwise, I will have to travel up to Delhi. So instead of traveling up to Delhi, using this avatar, I can interact in face to face. Whatever I will talk, he will reply. So it will increase. There's a chance of increasing more personal interaction. That's what I feel. But as of now, the system has not developed. But it will increase. It will increase. Definitely it will increase. Wait for that. By your time, it will happen like that. Okay. Yeah. So thank you. Thank you very much for the wonderful questions. And thank you, the organizers, for giving me this wonderful opportunity. Thank you.
Thank you so much, Anish sir, for your incredibly insightful and engaging session. Sir has explained how AI accelerating access to justice through the victims enforcement mechanism, lawyers, courts, and legislators, and to the extent to which AI can be used in access to justice. And moreover, sir has patiently interacted with us. So, sir, it was a really enriching session, and you have deepened our understanding of the intersection between law and AI. On behalf of Kilpark, Bangalore, the management, the principal, the director, the staff and students of Vaikuntha Balika College of Law, Udupi, and all the participants present here, I extend our heartfelt gratitude to you, sir, on gracing us with your presence and sharing your valuable insights with us today. And thank you all participants for your patient listening. Thank you so much.
As a token of appreciation, I request Jaya ma'am to present a memento to Dr. Anish. I once again welcome you all to the second session. Now we are moving on with the technical session 2. But participants, kindly note that in the next sessions, you will be given the opportunity to ask the questions at the end after all the 3 resource persons have concluded their paper. Now I request Preeti ma'am to give an introduction of Professor Dr. Babu Gowda S. Patil, Associate Professor, VM, Salgaonkar College of Law, Goa, presenting on the paper, Role of Law Schools in Promoting Access to Justice.
Good afternoon to all the dignitaries and participants joining us both online and through offline mode. It is my privilege to extend a warm welcome to all to the second technical session of the seminar. Today, we are truly honored to have with us Professor Babu Gowda S. Patil, Associate Professor VM Salgaonkar College of Law, Goa, as a distinguished resource person for this session, and I take this opportunity to introduce Sir to the gathering. Professor Patil has been associated with VM Salgaonkar College of Law for over 2.5 decades. He obtained his academic qualification from Karnataka University, Dharwad, with a specialization in labor law during his post-graduation studies. His research interest led him to the field of human rights of persons with disabilities, and in 2012 he was awarded a PhD for his thesis on right to education and employment of persons with disability. Over the years, he has actively contributed to various initiatives in Goa relating to disability rights and later expanded his expertise on mediation and negotiation. He played a significant role in introducing and developing a negotiation competition, making VM Salgaonkar College of Law one of the pioneers in ADR skill training in India. Along with senior colleague, he designed teaching modules for client counseling, negotiation and mediation, and also initiated a certificate course in conflicting management for students from diverse disciplines. Patil, sir, also serves as a visiting lecturer for the LLM program on human rights and ADR certificate program at Shivaji University, Kolhapur. He is empaneled as a resource person with the Karnataka University for Law and Parliamentary Reforms, Bangalore, an initiative of Government of Karnataka. Under UGC Pathshala project, he recorded 4 live lectures on access to justice, now available on the UGC website. Additionally, he is a member of the National Organizing Committee of the Lewis M. Brown and Marsden International Client Consultation Competition. Currently, he is serving as a national consultant to Vaya Vikas, a Bangalore-based social enterprise working on the right of senior citizen. He is also a member of the Board of Studies at Dayanand Sagar University, Bangalore, and has contributed to the law and process of adoption or as an advisory member of Center Adoption Resource Authority, Government of India. Within his own institution, he is a director of Internal Quality Assurance Cell and is actively involved in the implementation of national education policy. With more than 40 published articles and numerous paper presentations at prestigious national and international forums, Professor Patil has made remarkable academic contribution. He has also been invited to train faculty through faculty development program across India. So, with this remarkable achievement, what Sir has achieved, I'm delighted to present before you Professor Babu Gowda Patil, sir. Sir, on behalf of the institution and all present here, I extend you a cordial welcome. Welcome you, sir. Now I request Sir to deliver a talk on the topic, Role of Law Schools in Promoting Access to Justice. Over to you, sir.
Good afternoon, and the train is running late. So my session is supposed to start at 11:15. So we are slightly delayed. Slightly means a lot delay is there. And thank you for all your patience. And partially you also to be blamed for the delay because you have so many questions to ask. So now the organizers have found a way to deal with that by asking the no questions till all three presentations are done. My task today is access to justice, that is the role of law schools in that. Now, before I start my presentations, there are a few information that I need. May I know the institutions you all are representing? You? Saint Aloysius. Then? Vaikunta Boliga, VB. Then any other institution? Vivekananda Law College, Puttur, yeah. Any other institutions? Yes, ma'am, thank you. Any other? Arwas Law College. Arwas started with law also. Okay. Anything, any other institution, ma'am? Yes. Any other institutions? Actually, I want to know that how many law schools would listen to me and try implementing these, some of the few ideas. Yeah, okay, the live, there are many more institutions would be listening to me. And I think I'll be the first resource person wishing the audience coming on live because Anish and Jagdish forgot to wish them. Welcome to online. So, access to justice, role of law schools. Before I start discussing this, let me take up a question for you all. What do you mean by access to justice? Anish dealt with this question and he dealt it very crisp and short way and he has made it very clear because there are two aspects to this. What is justice and what is access? So when you look into the definition of justice, most of the discussions in Jagdish, Anish, even our director, Professor C.S. Patil, they are looking at litigation and justice in a litigation process. But I look at justice as a fairness. When someone approaches you, when you treat them fairly, you are doing justice. So, when we talk about this aspect, that it is not the court which is under the duty to provide justice. It is every one of us who should provide the justice. And even Professor C.S. Patil mentioned about why we are professionals and not a businessman. So that is, he explained that we are service oriented and justice is a product, that is the end product of our service. So therefore, when we talk about justice, we are not talking about lofty principles, but we are talking about justice in everyday interactions. Let me explain with an example. Now, if this old man comes to you and asks for a social welfare card, senior citizens card, Krishi card, he is in need of help. And if you ensure that the government of Karnataka provides the required card without bias, without delay, and without demanding too much of effort, that is justice to him because he got what he wanted. Look at this boy. This is the major problem with all construction industries because whenever the construction is going on, the children are going to be the one who is paying heavy price for that because these children have no access to education. And if somebody who takes, actually we did this job when we found that there are 20-25 children playing in the mud in a construction site. We asked, they said they have no access to school. We went to school. They were running short of children. And there were teachers who were actually be transferred to some other place because of the lack of students. Now see, there is a necessity and there is a necessity, but nobody is bringing them together. So it was a simple task for us. So that is again a justice for us. Then comes this one, garbage removal. There are two ways of doing it. We can ask our NSS volunteers, come up, roll up your sleeves, clean it up. But as a law student, we should make the state to work. It's not that we work. So as a law student, we approach the relevant authority, make him work, make a petition, ask him to do his job properly. So that is where justice lies. So as a law school, when you look into these things, the first question arises, is providing access to justice is a job of a law school? Now, until unless I answer this question, I have no right to continue with this. Am I burdening you additionally other than passing the exam and becoming a lawyer? This is an additional burden I'm putting on you. My answer to that is a big no. Because first, when you look at it, we have two jobs as a professors of a law school: knowledge and skill. When we give lecture, we are imparting the knowledge, but where the skill are going to be imparted? You have to learn. Now, a science college will have a laboratories. They go to the laboratory, they do practicals, they learn. They learn in a practical way. And where is our laboratory? Our laboratory is the society itself. It's a lab. Come out of the classroom, get into the society. You will learn a lot many skills. Take the example of garbage removal. What kind of skills you will learn? You will learn drafting. You will learn PR skills, public relation skills. You are going to speak to the authority. Persuasive skills. You are going to convince him to do his job. And then most important one is you understand the hierarchy. If this fellow doesn't listen, where to go, from where to go. You understand the hierarchy and you follow the hierarchy properly. You don't jump the authority. See, all these are important skills you are learning, and this is what happens when you try to provide access to justice. If you think that you are helping the society by doing this, you are not wrong, but you are not completely right also. Because by providing access to justice, you are getting access to skills. This. When you work in this area, you bridge the gap between law in schools and law in courts or law in action. The first thing when you go to the court, leaving the classroom, you feel exactly like a fish which comes out of the pond onto the land. Why that gap? That is because you have knowledge of law, but you don't have skills of a lawyer. And that gap we are going to bridge with this exercise. Reducing the incumbency. Because when you go to the court, you learn another 4 or 5 years. What you are learning? You are learning all the skills necessary for practice. But if you start access to justice program in the college, you reduce that incumbency period. I'm not saying that you are going to eradicate it, but you definitely reduce it. In my experience, some of the students, when they pass out with the clients in hand, because their legal aid clients, they continue to approach them. They already have clients when they pass out from this. See, this is what you achieve by doing access to justice. Most of us feel our job is done when you make you remember the provisions of law, section number, contents of the law. But we need to go to the next level, understand it. Then next level, apply it. Legal aid starts here, when you start applying your knowledge. And you apply your knowledge, then you analyze. You analyze, you divide, you break down the law and try to analyze it. And then comes evaluation. You try to understand the effectiveness of the law and why it is not so effective. The first session which Jagdish took is all about making CPC more effective. Now, how he reached that level? He is not only remembering law, he is already evaluating it. And then one step further, create. They are creating new provisions so that the law becomes more effective. Now, I want you all to climb all these steps. And this is possible. It's not that, but it is not possible in the classroom. You have to get into the laboratory. And what is our laboratory? The society. Get in, speak to strangers, you will learn a lot. So let me skip this. We all talk about legal aid, we all talk about access to justice, but all discussion is about inside litigation services. But what about outside the litigation services? There's a huge, large area is there where nobody is competing with us. Inside litigation services, there are lawyers, there are other stakeholders. They all hate us entering into that litigation process because they feel that we are snatching their bread and butter. But outside, there is nobody to compete with us. If we do our job, government will be very happy because government has a bigger task to handle. Now see, state has to provide access to justice, correct? It's their primary job. And we are doing their job, not because we want to help the state, but because we want to help ourselves also. So the biggest challenge is this. The challenge is of access to justice. AI, this is what most of you expressed when Professor Anish was presenting. So if I don't know use of AI, what to do? Because when I was attending an international conference, one Sri Lankan student, he said, sir, to provide access, everything went online. It became internet-based. Applications were available online. But a poor man, a villager, doesn't have access to internet. If he has access to internet, he has access to justice. Now that's why the question, access to justice. When we provide a facility, the facility should be accessible. That's where we come in. We are not heroes. We are not bringing great change, but we are bringing small changes continuously, which cumulatively becomes a great change. So that is what is expected. Because when I was delivering a lecture in Bhopal, a girl came and asked, sir, there is a murder in my locality, shall I take it up? I said, that's not legal aid. That is suicide. You are not a hero. You do small things, clean the garbage in the area. Because first thing, you have to build the trust of the society in you. The first thing which we don't have is the trust. The moment students come, people don't take you seriously. How do you create seriousness about yourself? How do you build a trust? That's image building. The image building is you do small things, show the result, they start believing in you. So this is the laws which deal with duty of state to provide legal aid and access to justice. And all these things will be dealt by my next presenter. But mine is this, expectations from the legal education. Now I'll give you 7 areas. These are the 7 areas where you can provide access to justice. The first one is legal representation. That's where we have a lot of hassles, a lot of limitations. But we have overcome those limitations. Because see, harping on the problems is easy. Finding a solution around the problem is what we are supposed to do. So let us not gossip around, let us not sit and crib around, but let us find the solution. Legal awareness is the easiest. And we should do that, we should not ignore that. Legal advice, it comes only when people start believing us. Because then only when the client comes only, you can provide the legal advice. Paralegal services is the best way to build confidence in the society. What we have to do under these things, I'll give you glimpses of it because of the paucity of time. Public interest litigation is again a great way forward. Soon, hopefully, if our technology permits, from Udupi we can file a PIL, and from Udupi only we can argue the case. If that happens, then the justice is at your doorstep. So that's what is expected. Then promoting ADR, you are already doing it, and I am not a right person to talk about it because you are doing this much better than any of us. Then comes the last one, the law reform. The law reform is going to be the best legal service that can be provided by any institution because yours is an educational institution. So let us take up, I will not go in detail with it. It's not about my college, it's about access to justice. So I'll take you to this one. legal representation. I said we have cracked this task. So what we have done? Child rights clinic students, the teacher went, spoke to Juvenile Justice Board, and we convinced the judge that the children will open up if someone of their age is speaking to them. They speak more freely. Based upon our persuasion, JJB presiding officer allowed one student to interact with the child who is victim or child who is in conflict with law. So that interaction, that noting down of the examination, everything, that was an invaluable experience. Then we went to CWC, that is Child Welfare Committee. With the Child Welfare Committee, we started inspecting the children home and other thing. We are around 1,200 students, but out of that we might have given an exposure to 20 students. But it's a small way, but we have started doing that. Then the presiding officer changed. The next presiding officer did not agree with us. The next presiding officer said, no, this is a process, judicial process, we cannot include children. Our students become children to him. So we lost. But we waited for him to get transferred. Again, after 3 years, we found another presiding officer who was very conducive to our idea, and we restarted the whole thing. See, we are like a politicians. If we lose one election, we contest next election. And that's the best way to, because that's one thing I learned from the politicians. Always be in circulation, come on the newspaper, make some news, then when the election comes, you stand a chance. So that's what we have done it. But consumer clinic was much easier one. We found a judgment, and a judgment it is written, a next friend can appear. There is no need for an advocate, a next friend can appear. We went, we took the judgment, gave it to the presiding officer, and he allowed. Same, next presiding officer refused. Then we took it as a challenge and we questioned him in the open court. We said, this is a judgment, you are going against the Supreme Court order. Now we have already represented 25 cases in a consumer clinic, and all cases are drafted by us, argued by us. Us means students. We only guide them. Now presently we are going with a case where petrol pump gave up contaminated petrol to a vehicle and the engine seized. So that case is going on. So this is, and we get repeat clients also. When service is free, they tend to exploit us. We don't mind, please exploit us. Because we need cases so that we get experience. Center for Persons with Disability is another one which was started by me. We work closely with the Commissioner of Disability Persons, and here we have developed one app. You take a mobile, enter a building, it starts studying the accessibility. So the ramp, the angle is correct or not, width is enough or not. You just start clicking the photographs. Open the app, start clicking the photographs. The photographs gets collected, in 10 minutes it generates a report. The building is accessible or not. So our students are trained in that. They visit public places and start doing that thing. So this is as far as legal representation is concerned. Legal awareness, we have adopted innovative things to do. Here, these are the cartoons that we drawn. This is the best way of communicating, especially if you are going to a school. We came across with one NGO called Metamorphosis. So they were teaching cartoon making. So we trained our students and we designed many posters, and we went to schools and delivered it to the schools. We achieved some kind of a legal awareness because you have to talk to the children in their own language. We can't give them section numbers and also talk about the rights. And then we had another NGO which trained us in performance, street plays. And by that training, we know how to do the script writing. And in the script writing, we have to include some Bollywood songs so that we attract the crowd's attention. And then in that Bollywood song also, we fine-tune the lyrics so that we can insert some rights in that. And then the story starts. So the first rule here is we cannot use costumes. That's the first rule of street play. It should be, we can have an uniform but not costumes. The other one is Jansunuai, where we bring the authorities and the public asks directly questions to them. This is about human trafficking. Wasco has one red light area called Baina. It's a beach area. So there we had this Jansunuai thing. Paralegal services is another area where we can do really good work. The first 3 photographs what I showed, they are nothing but a paralegal services. If you fill a form of a farmer or an old man or for senior citizens, you are doing paralegal service. You are providing the help that is required. So these are some of the paralegal services done by us. And in recognition of this work, after visiting the jails, we got an invitation from the state of Goa. August 15 and January 26, there's a remittance. The convicts are given concessions, like they release after 15 years, 12 years in the jail. And we are supposed to prepare a report, whether he fit to be released or not. So we visited the person who has applied for remittance. We visited his jailmate who is sharing the same cell. Then the jail authorities, his family members, and the family members of the victims. After these 5 interviews, we gave the report to the state. So this is, we are doing it from last 3 years. Now imagine the exposure the students are getting when they do all these things. And sometimes they are opening up to the reality of the world. One jail inmate, he had no relatives, he had only son. When he was arrested and convicted, the child was a minor. And we don't know, because until unless we speak to his family member, we can't submit a record. Then we went to victim's house, requested the victim, can you connect us to his family member? They gave the phone number of the boy. They had pardoned this man long back for what he has done, the victim's family. But the law had not pardoned him. And when we called him, he had already settled somewhere in Hubli or some other places, Gadag. And then from there he came, took a bus and came. By now he's a teenager. He came, he said, yes, I want my father back. Victim said, see, whoever is gone, but let the father and son stay together. We gave a report. We cannot recommend. We only give the fact. The state has to decide whether to release or not. Luckily, he was given a remittance. So this is how you get recognition. Once you get recognition, things open up. So registration of birth and deaths, we sit in the office, we do the registration of those things. Clerks are very happy because we are doing their job. So clerks really become very happy when we do those things. But anyway, it's a learning process for us. And this is, next one is the something which we have done, 22 public interest litigations we have filed successfully. Again, not a heroism. What are the public interest litigation? Use of helmets. The CRZ was one major issue because we faced a lot of problems, because CRZ violation means violations by multimillionaires who are running hotels or their bungalows. So we actually brought down at least 28 structures through this litigation. Construction of ramps for the disabled persons. State of Goa won the best disabled friendly state in India. And the director was angry because we filed this PIL, and he went to receive the award. We are not called to get the parking space was another one. We could not continue with it because of problems, because Panjim is an area where every square inch is sold in lakhs of rupees. And we found that most of the buildings fail to adhere to this parking zone requirements. But we could not proceed with it because of risk involved. Sanitation was the easier one. Constitution of JJB and the Constitution of State Human Rights Commission. That's again the great achievement. The State Human Commissioner was called to college to deliver a lecture. Then he asked, who is the reason? for me standing here. One student stood up in the crowd. And they asked, why you are the reason? She said, sir, I filed a PIL and state constituted a State Human Rights Commission. She was a Savita D'Souza. So because of her initiation, SHRC was constituted and it is still functioning and functioning very well. And a case was filed against the college in SHRC. So we have to pay the price also for doing good work. Illegal stream farming, this again environmentally very damaging activity where we allow the seawater to enter on the land and we do the shrimp farming. The land becomes unusable for agricultural purposes. So there were illegal shrimp farming was going on and we stopped most of the thing. How we recognize, how we narrow down to a topic. It's all the students. One student came and said, sir, in my village, roads are very narrow, sharp turns are there. We need the concave mirror so that to avoid the accident. I asked him, you are born and brought up in that village? And now after 20 years, you found the problem. He said, sir, now there is a pressure as on to identify the problems because we have to show legal aid work now. Because the moment you open up your eyes, you identify the problems. This ADR, I will not take up detail about it because ADR is a process where you try to solve the problem between two individuals, which is already been done in this institution. How it started? It's basically through sensitization. And then one I suggest for Vaikunta Baliga Law College is to start a training. 40 hours training if you do, because the reputation that this institution has in mediation, nobody else can match it. You design 40 hours course, start delivering the certificates. They can become a professional mediators. So we may have highest density of mediators in Udupi as compared to the rest of India. But we cannot stop at only solving the problems. We have to build the army of mediators who can solve the matters. And why can't we? Anyway, we have an ADR center. Similarly, we can start the branches in different institutions because we have to spread the good deeds. Good practices has to be shared. And the law reform, this is the last one. The law reform, what we have done is we identify a law, we discuss when it is in a bill stage, and we send the recommendations. One good thing here is the moment you send a recommendation, your name gets registered in the discussion. So our names are there as faculty of V.M. Salgaonkar College of Law, where we made recommendations for Mediation Act, we made recommendations for some of the legislations. So again, it's basically keeping your eyes open. Go to PRS India. In the PRS India, there are committees are set up, that is parliamentary committees, and they would be inviting suggestions, open any law, discuss for 2 minutes, make suggestions, maybe good, bad, agreed, not agreed, but at least the effort has started. So try doing that. And I feel we may help 1 or 2 individuals, but if you bring a law reform, you are assisting millions of people at a time, because the changed law can bring justice to them. So this is something that you have to keep in mind. And these are the best practices that are available all over India, because there are institutions doing in Haryana and Chhattisgarh. They are doing tremendous job as a law schools. And I'm leaving my slide with the Vaikunta Baliga. You can collect from them. You can use for your further implementation. Okay, thank you very much. Thank you for your patient hearing. So now I'll call upon, no, I cannot, there is a process here.
Thank you, sir, for emphasizing that legal education plays a very important role in socializing the next generation. And for achieving a just and equitable society, the law schools can be a good platform in promoting access to justice. Sir, you have motivated us by your research, by your work that you have done towards the society, sir. Probably the next generation will also do that. It's a motivation even for us, sir. Thank you so much, sir. And it was a very insightful presentation. On behalf of all present here, I extend you a very heartfelt gratitude, sir, for accepting our invitation. Thank you so much, sir. So on behalf of the organizing committee, Kilpar, we would like to give a memento to you, sir, as a token of appreciation. Thank you, sir.
The topic, Tribal Movements in Post-Colonial India and Access to Justice, by Professor Dr. T.R. Moti, Professor of Law, Department of Studies in Law, Chairman, School of Law, University of Mysore. Now I kindly request Navin sir to introduce the resource person.
Good afternoon to all. Once again, I welcome you all to one-day national seminar on dimension of access to justice, challenges and way forward. Respected resource person of this session, dignitaries, paper presenters, participants, colleagues, and my dear students. I, Dr. C.B. Navin Chandra, Assistant Professor, Vaikunta Baliga College of Law, Udupi, deem it my privilege and pleasure to introduce my Guru, Professor T.R. Maruti Sir, Professor of Law, PG Department of Studies and Research in Law, University of Mysore. Sir was born in Shivamogga district and was brought up in the heritage city of Mysore. Sir obtained law degree from Coimbatore University in 1998 and pursued his MA and LLM from Mysore University and obtained PhD degree in law in 2007 on the topic Legal Regime of the Seabed, a Critical Study under the guidance of Professor P. Iswar Bhatt Sir. Sir has more than 25 years of teaching experience and he rendered his services in various reputed universities as a teacher, enlightening the young minds to acquire more knowledge. Sir has successfully produced 19 PhD students on various legal issues. Some of the PhD theses have been published in the form of book. Sir authored various books and has participated and presented more than 100 research articles in both national and international conferences. Sir has expertise in the field of international law, international human rights law, international humanitarian law, private international law, international economic law, United Nations system, law of sea, air and space law, intellectual property laws, and environmental law. Behind his role as academician, Sir is stalwart in saving legal education, being pioneer of Model United Nations conferences in the University of Mysore. His stewardship includes membership in prestigious committees and councils such as the Academic Council, Syndicate, Statute Committees, Board of Studies, Selection Committees, and many more at the University of Mysore, where his sites and foresights have helped sculpt the future of legal scholarship. A testament to his global impact, Sir has lent his expertise to international bodies such as United Nations Commissioner for Refugees and International Committee of the Red Cross, engaging pivotal dialogues on human rights, environmental preservation, and crisis management. With this brief introduction, I present before you Professor Dr. Maruti T.R. Sir. Once again, I welcome you, sir. Thank you.
Good afternoon. First of all, let me extend my heartfelt gratitude to Professor C.S. Patil sir for giving me an opportunity to share few thoughts about tribal movements in the post-colonial era. In fact, I wanted to speak on AI in connection to legal research in India. I received a call from Professor Navin Chandra. He asked me to talk on tribal movements in India and access to justice. Perhaps you may have gone through what is justice, what are the contents in it, how exactly justice shall be looked into. And moreover, if rather I would say, an insight into the subject matter of justice is not so simple. This is there for centuries and civilizations as well. What is civilization and the culture? Culture means what we for is our culture, what we do is our civilization. You just have a look on Mesopotamian civilization, Harappa Mohenjo-daro civilization, Indus Valley civilization, Greek, Roman, all in all you have gone through. Series of thoughts have come in with you to understand the concept of justice. Perhaps you may have gone through series of cases decided by Justice V.R. Krishna Iyer. What he says, access to justice is one among human rights. This is what he has been emphasized on the basis of justice as well. You know very well better than me, law looks as if crude oil. Justice is refined oil, less cholesterol, triglycerides. So you have to understand from the perspective of the contribution made by Aristotle, wherein he could share on the basis of a distributive and corrective of justice. These are the basis of John Rawls' philosophy of law, none other than theory of justice, wherein John Rawls has outspoken on the basis of the concept of justice. This is one thing. If at all you want to look into the matter very seriously, have a look on our own jurisprudence, wherein it has taught us to understand the concept of justice from bottom to heaven as well. We can say on the basis of Cusa Sestu Solem, each state has got rights from earth to heaven. Nobody knows heaven, still we believe. These are the things we have come across when it comes to the knowledge of the concept of justice as well. On the other hand, if you just look into the world arena, series of crises are remained even today. It's very difficult to resolve them. Sometimes you may not be in a position to find out a solution as well. There are three conflicts in our society. Number one, man with nature. A conflict between man and nature is remained even today. A solution can be found through science and technology. Through science and technology, you can find a solution in connection to a conflict between man with other men as well. The second, the man with other men. When you are dealing with a conflict between man with other men, obviously the politics will come and help you. Last but not the least, you have got your own problem, I have got my own problem. How can you resolve your problem? How can I resolve my problem? So based on yoga, meditation, spiritual activities, we can work on. So these are the conflicts we are just finding in our own holistic and integrated society as a whole. This is one thing I would like to share before I'm just starting some thoughts on the subjective and objective approaches on the tribal movements, country like India as well. Of course, if X happens, then Y ought to happen. If X commits a crime, he should be prosecuted. That is our jural relations. This is what Dias has emphasized in his jurisprudence as well. Anyway, if somebody is actually crying at home, mother should know why he or she is crying. That is our culture. You have to understand from the family itself. You may say charity begins at home. Sometimes violence begins at home. That's there. We have to balance in the society as a whole. Otherwise, it's very difficult to understand the concept of justice as well. Let me share with you on the basis of some conflicting interests. Sheep is actually standing before wolf, vice versa. Wolf is actually standing before sheep. Wolf is asking, "Hey sheep, I have a right to food, I want to kill you." Then sheep replied, "Wolf, my friend, however you might have got right to food, I have a right to life, you cannot kill me." This is one of the tricky questions I'm just sharing with you. when you are listening to understand the concept of justice as well. You cannot ask a lion, leopard, or tiger, hey, go and have green grass and green leaves. You are living in thick forest. They are all actually biologically imbalanced. Similarly, my wife cannot ask me to have mother room. How can I have mother room? I am biologically imbalanced. So these are the tricky issues and challenges we may be expecting in the society as a whole. This is one thing I would like to share with you. On the other hand, just look into world arena. When you are close to high temperature, high fertility will come. When you have got high fertility, population will be increased. So therefore, issues are widespread all over the world. It could be on the basis of Eurocentric, US-centric, or Asia-Afro-centric approaches. This is one thing I would like to share before you all. Let me share with you in otherwise manner. Before establishing as many as mechanisms at the national, international level, we were under the mercy of colonialism. People were actually controlling us. Now we have got all mechanisms to decide. This is what one could understand it in otherwise manner as such. On the other hand, if rather I would say, what is colonialism? How exactly colonialism was successful in controlling all in all? How exactly you have overcome colonialism? How are you dealing with the neo-colonialism or post-colonial approaches? So these are the fundamental questions shall be asked when it comes to knowledge of the people who are living in very marginalized sections of the society. Take for an example, Soligas. Perhaps you may have visited BR Hills, Biligiri Rangana Hills, then Ankola, Joyda, then HD Kote, Nagarwale, Bandipur. Perhaps you may have visited. All in all, even today, they are living in miserable conditions. Now we are sitting here to understand access to justice. What about these people? They are highly marginalized even today. They are not accessible to have minimum necessities, food, clothes, shelter. Of course, we have got series of legislations. We have got our own constitution. Constitution that itself is suprema lex and lex specialis. Everybody knows. You just look into all these articles, Article 14, 15, 16, 244, 344, 2, all in all, they are dealing with these vulnerable groups. However, the problems are remained even today. We have been actually keep researching that the problems are remained. This is very serious issue, if rather I would say, when it comes to the knowledge of the tribals who are living in these critical conditions as well. This one thing I would like to share before you. On the other hand, of course, no matter when the population is increased, your planet is going to become smaller and smaller. This is what one should understand. Even in otherwise manner I can share. Song is actually better than singer. So that should also be actually looked into when it comes to knowledge of these people who have been actually living in the miserable conditions as well. On the other hand, philosophically, one can address, this is what Leo Tolstoy said long ago. One of the first conditions of the happiness is to bridge the gap between man and nature. That shall not be broken. So man and nature, they should go hand in hand. Just see and visit these places like, BR Hills, Ankola, Joyda, even Nagarwale, Bandipur. You will be known how people are living in miserable conditions as well. They are not accessible to have minimum necessities as well. As I said, food, clothes, shelter as well. This is one thing I would like to share with you. On the other hand, after having gone through a series of developments that are taking place at the international level, everybody knows what's going on at the international level as such. So without understanding UN mandates, it's very difficult to have a look on access to justice. Just to see the preamble of UN Charter 1945, wherein it starts with the we the people of United Nations determined to save the succeeding generation from the scourge of war. There shall be international cooperation and mutual coexistence. For what? For promoting and encouraging human rights and fundamental freedoms without distinction with race, sex, language, and other religion as such. This is very important from the point of view of understanding the concept of justice as well. There is no exception even for tribes who are living in these areas as well. This is one thing I would like to share with you. When GATT was initiated in 1947, GATT was actually giving more importance to developed countries. We in fact faced a lot of problems when GATT was initiated. We could take more than 3 decades to react on GATT. Especially in 1960 and 1970, there was an awareness among these developing countries to react on the subject. That's why new international economic order was initiated. Why new international economic order was initiated? New international economic order was initiated with a view to target developed countries as well. Of course, you may say, in otherwise manner, there shall be closest connection between haves and have-nots. How will you understand haves and have-nots? So what measures you may be finding with a view to understand the conflicting interests between haves and have-nots? So these are the problems are remained even today. So based on these, I would like to share in this way that there shall be cross-cultural ethos. So without understanding cross-cultural ethos or cultural change or cultural relativism, it's very difficult to understand the people who are living in thick forest areas. It's very difficult to understand them. So therefore, I would like to share with you, whenever you are free, please visit these places. So based on, as Sir rightly pointed out, on the basis of legal aid camps, legal aid camps should be conducted in these areas, understand their social, economic, cultural issues, how exactly these issues should be overcome on the basis of certain legislations as well. This is one thing. Of course, we have got many legislations which are addressing the problems of a tribal country like India. There is no second thought in it. However, you may be finding certain loopholes in the provisions of law, but you should give more importance to the objectives of enactment. That's very important from the point of understanding objective and subjective approaches of law as well. No matter, each state is a supreme in eye of law. It can pass any legislation, amend any legislation, and repeal any legislation. It has got an autonomy, as stated in the Article 2, Paragraph 1 of UN Charter 1945. There is no second thought in it. Who bells the cat? You have to bell the cat, isn't it? You have to catch the cat, bell the cat. Simply, you cannot have sweeping statements or safe cornered statements as well. This is very important from the point of understanding these issues and challenges as well. Of course, these people who are living in these common areas have been actually facing a lot of crises based on communism, dictatorship, democracy, socialism, and military. Which is supreme in eye of law? It is a fundamental question. This is one thing. In earlier days, did you find any passport visa? Did you find any fence, 20, 30 sites? We did not find, isn't it? The entire world was actually belonging to all people. Vasudhaiva Kutumbakam. That concept came in based on these perceptions and ideals as well. So anyway, let me share with you, these tribals have been actually gambled with these developments as well. So that you should overcome when you are listening to understand these tribes as well. Let me share with you, when you are listening to these tribes, there are series of crises like land alienation, look into forest rights, economic exploitations, the preservation of tribal identity and the culture. Everybody knows violation shall not be tolerated. Discrimination shall not be tolerated. Vis-a-vis. And you cannot be stronger by exploiting others. All are equally fitting. Nobody is actually superior or inferior. Please remember, as it is well noted under the basis of Confucius and Lao Tse philosophy as well. You have to understand it. This is one thing I would like to share with you. On the other hand, like should be treated alike, unlike should not be treated alike. Equality before law and equal protection of law, they should go hand in hand. This is what even many scholars like Aristotle could share. It is compatible with the legal systems that discriminate between free men and slaves, between blacks and whites, between rich and poor, between men and women, for all these class concepts. This is what Aristotle could make a note of it in connection to the subject matter of the concept of justice as well. On the other hand, have a look on one of the statements given by V.R. Krishna Iyer on the concept of justice. The man's greed attacks nature and environment and ecology, and wounded nature backlashes on human nature. This is what I would like to share with you. On the other hand, humanism is the soul of justice and all social sciences as well. This is what V.R. Krishna has emphasized accordingly. Even in otherwise manner, please have a look on one of the statements given by Herbert Spencer. What he says, no one can be perfectly free till all are free. No one can be perfectly moral till all are moral. No one can be perfectly happy till all are happy. So we have to understand in this way. So you, as students of law, should come forward with some action plan to see the social, economic, and cultural issues and challenges in the society as well. I mean to say, you have to understand triple justice. What is a triple justice? It could be political justice, economic, and the social justice. This is what, in one of the interesting cases, Justice Chagla could refer. Prakash Cotton Mills versus State of Maharashtra, wherein he says, without understanding social justice, law cannot be interpreted. In a silver linings, series of thoughts have come in with a view to understand the concept of social justice as well. So social justice should be looked into, and moreover, if rather I would say, an insight into the subject matter of social justice is not so simple. It requires a lot of drill. You have to understand socio and milieu of the society as a whole. This is one thing I would like to share with you. On the other hand, if rather I would say, one of the statements given by Stephen Vego in his book, Law and Social Change, wherein he says, law is an instrument of social change. It may change from time to time as a science and technological development as well. This is what Professor Anish has already pointed out, how exactly a synergy can be created between science and technology and the society as a whole. They should go hand in hand when it comes to the knowledge of these issues and challenges as well. Have come in mindsets as well. So Homi Bhabha explores the complexities of cultural and identity On the other hand, agonistic democracy, which is actually shaping political and social life, even in otherwise manner, you have to have a look on the concept of the rule of law and the citizenship. This is very, very important. Who are these people? Those who are living in the forest, they are all actually from our own places. You have to understand them. You have no moral right to sideline them. It is because of mega projects issued by state and central government, people are actually displacing from one place to another place as well. And you know very well, better than me, except Article 21 of Indian Constitution, no law is there to understand the internal displacement country like India. In 2005, a bill was actually placed before Parliament, but it was unsuccessful. Fortunately or unfortunately, we have certain guiding principles which were actually drafted by Francis Deng of Sudan, who was actually appointed by Secretary General of the United Nations with a view to understand or research on IDP all over the world. You could visit as many as places, came out with guiding principles on internally displaced persons. At least for refugees, you may have had as many as agencies. For these people, you don't find a certain, what shall I say, specific protections, a country like India. So therefore, you have to understand the problems of internal displacement, country like India. This one thing. We have had more than 7 lakh internally displaced persons, country like India. There is no law at all. So we need to explore ourselves with a view to have some specific legislations which could be helpful to these people who are living in miserable conditions as well. We have as many as international instruments, perhaps you may have gone through. You have UDHR, ICCPR, then International Covenant on Economic, Social and Culture in 1966, UN Action Plans, Beijing Declarations, so many international conventions we have. Only thing is that you have to understand transformation of international human rights law into the municipal law. This is one thing. We have failed in understanding this, if rather I would say. Of course, no matter, Article 253 is very clear about the constitutional validity of public international law. Thanks to the highest policy makers, country like India, on the basis of these factors, to transfer or incorporate such kind of international law into the municipal law as well. It's a debatable issue. Perhaps you may have gone through as many as theoretical perceptions on the municipal and international law. We have monism, specific adoption, then delegation theory, harmonious construction theory. All in all we have, but we have failed in understanding the transformation of such kind of international law into the municipal law as well. We are just signing. The ratification is to be looked into, isn't it? The ratification should also be one of the part and parcels of the treaty making process, but we have failed in understanding the treaty making process as it is well noted under Vienna Convention on Law of Treaties 1969 as well. This one thing I would like to share with you. So these are the legislations which are addressing tribals, country like India. So just have a look on. So major tribal groups in Karnataka. We have Soligas, who are living in BR Hills, Jenu Kurpa, Hakki Pikki, Koraga, they are in Udupi, Yarava, Banjara, Bil, Gond, Toda, Siddhi. Especially in connection to the issues of Siddhis, they were actually migrated from Africa initially. I have visited almost all the places in Karnataka. I had an opportunity to work with the 2 major projects funded by state government. One was on conservation of natural resources in the state of Karnataka and the protection of tribals in the state of Karnataka. That all these were actually based on internally displaced issues and challenges as well. Siddhis are actually divided into three: Hindu Siddhi, Muslim Siddhi, then Christian Siddhi. So this is actually somewhat tricky, especially in Jaida, Ankola, and even some parts of Hubli. We are witnessing all these people. They are in fact living in miserable conditions as well. These are the important tribes involved in a revolt in the 17th century. Then movements due to exploitation by outsider, movements due to economic deprivation, movements due to separatist tendencies. Because of these reasons, tribal movements are quite common, especially in a country like India. These are the revolts. Please have a look on. Jharkhand movement, Naxalite movement, Naga movement, movements in Odisha, movements in Manipur. All in all we have. Just look into positions in Karnataka state. Struggle for land resources. Then, especially in Nagaravale, Bannerghatta National Park, it's quite common. Displacement due to conservation of policies, then demand for rightful land ownership and title deeds, the fight against exploitation and forced labor are seen with these areas are concerned. There is a clash between tribals and forest officials. This is remained even today due to many reasons as well. This should overcome as far as and on the other hand, and you know very well, in absence of specific legislations, states are actually relying on the basis of a report submitted by various experts. We have a Madhva Gadgil report, Kasturi Rangan report, Oman Chandi's report. So you have to understand these reports while you are researching on tribal population in the state of Karnataka as well. And you know very well that Western Ghats covered with 6 states, 46 districts, 146 talukas, known for many organisms, and room for all these discussions as well. It should be meant for good oxygen. It is because of your mega projects issued by the state and central government, everything is actually damaged. This is very serious issue. Tomorrow we may not be finding some species as well. Most of the species, plants, trees are endangered in situation. Of course, we have had series of principles and doctrines which are addressing protection and preservation of human environment. We have polluter's pay principle, sustainable development, precautionary principle, common heritage of mankind, common concern of humanity, common but differentiated responsibility. All in all we have. But the problems are remained even today. This is very serious issue. We have to understand in otherwise manner. This is what I would like to share with you on the basis of a report submitted by Professor Asadi. This report is actually not implemented properly, especially in the state of Karnataka. We have neglected this report. Otherwise, you would have given more importance to the people who are living in Nagaravale. So therefore, in this way, anyway, however, you may have gone through a series of crises in connection to the subject matter of tribals in the state of Karnataka. This is the right time to give an opportunity to access the justice as well. These are the agencies which are working. We have got our own welfare programs to overcome the problems of tribals in the state of Karnataka. What are the action plan? So at the end of this technical session, I have come across with some action plan. Kindly have a look on. You have to go for amending certain provisions of these various legislations as well, like FRA, then Protection of Biodiversity 2002, PESA Act. As many as legislations are there which are addressing the issues of tribals in the state of Karnataka entirely. However, wherever you may find some difficulties in understanding the provisions of law, as it has been actually rightly pointed out by Dr. Jagdish Halasetti, we have to go for amending the new, I mean to say, legislation should be amended on par with the social changes as well. This is one thing I would like to share with you. There shall be awareness. Programs should be conducted in these areas, and you have to respect traditional knowledge of these people who have been actually running since time immemorial. Then you have to give more importance to their generic medicine or ethno medicines. No rehabilitation has been made so far till now, especially in these areas are concerned. You have to give adequate importance to rehabilitation process as well, so that you can overcome the problems in connection to tribals. You have to educate them. And on the other hand, you have to give more importance to their languages. When we were just drafting the Constitution of India, we had 75 primitive languages. Now we have 50 languages. We have lost 25 languages in India. This is very serious issue. So therefore, Bharatiya Bhasha Samiti in Delhi is actually giving more importance to teach the students in their languages as well. I think that would be one of the best methods where these people can be functional on the basis of the concept of the justice as well. This is one thing. At the end, I must share with you on the basis of postmodernism. I think postmodernism is one of the best policies, if rather I would say. You have to balance the interest between haves and have-nots. It means capitalism and the communism should be balanced in the society. Otherwise, these problems would be remained. So with these few observations, let me extend my heartfelt gratitude to organizers for giving me an opportunity to share few words about tribal movements in India. Thank you very much.
Thank you so much, sir, for your insightful session. Your insights regarding tribal movement to access to justice has really enriched our understanding. On behalf of Kilpar and Vaikunta Baliga College of Law, I extend heartfelt gratitude to you, sir. Thank you, sir. Thank you so much. And also, thanks to all the participants for your patience listening. We have memento, sir. Please.
Our last presentation will be on the topic Access to Justice, Constitutional Mandate by Dr. K.C. Girish, Assistant Professor, KSLU Hubballi. I now request Raksha ma'am to kindly escort sir to the dais and give his introduction.
Good afternoon to all the esteemed resource persons, distinguished participants, and my dear colleagues and students. It gives me immense pleasure to extend a warm welcome to you all to this technical session of one-day national seminar on Dimensions of Access to Justice, Challenges and the Way Forward, organized by Karnataka Institute of Law and Parliamentary Reform and Vaikunta Baliga College of Law, Udupi. It is indeed my privilege and honor to introduce and welcome our distinguished resource person, Dr. K.C. Girish, Assistant Professor, Karnataka State Law University, Hubballi, who will be delivering a lecture on Access to Justice, Constitutional Mandate. Dr. Girish has had a remarkable academic journey. He obtained his BA LLB from Mangalore University and completed his LLM in Constitutional Law from University of Mysore and secured a gold medal for the highest marks. He was also a merit awardee of the Ministry of Education in the pre-university examination and received another gold medal for the topping in economics at University College, Mangalore. In his professional career, Dr. Girish has made remarkable contributions to academia and training. He has delivered training sessions for officers of the IRS, IFS and Central Pollution Control Board. He has served as state coordinator for Uttar Pradesh in UNDP Access to Justice program and has held significant administrative positions such as Directorate of Student Welfare at KSLU Hubballi, University NSS coordinator and chairperson and Board of Examiners member of the Postgraduate Board of Studies. He has also enriched institutions by serving as a permanent faculty and academic council member at National Law School, Raipur, Chhattisgarh, and as a faculty at VM Salgokar College of Law, Panaji, Goa. Dr. Girish has been an active scholar and participant in the academic community. He has delivered lectures at numerous national and international conferences, acted as a resource person in various seminars, and presented research papers at both international and national platforms. His scholarly contributions include the publications of articles in reputed journals. At present, he is serving as a head Center for Research in Water Resources Management and Law, as well as head Center for Research in Democracy and Constitutional Government. In addition to his role as Assistant Professor of Law at KSLU Law School, Hubballi. We are truly delighted to have you with us today, sir, and we eagerly look forward to your valuable insights. With these words, now I request and invite Dr. K.C. Girish, Assistant Professor of KSLU Hubballi, to address the gathering. Over to you, sir.
Most respected Professor Dr. C.S. Patil, sir, Director of Kilpar, as well as my guru and my research guide, and the Principal of Vaikunta Baliga College of Law and the Director of Vaikunta Baliga College of Law in their absentia, and all other resource persons who are present here, and all the students who are present in this particular auditorium. So, good afternoon to one and all. And the topic on which I am going to deal for a few more minutes is access to justice, constitutional mandate. Before moving on to this particular topic, like always as a teacher, one thing what I get reminded is the examination application tumbud mele classic barod bitbiಡ್ತಾರೆ ಮಕ್ಕಳು. Andre, the last 15 days, they don't attend the lectures. That is always the legacy, what is being continued at the fag end. So now this is a 6th technical session, and I am here to speak about access to justice, which also has a human rights perspective and dimension to it, and right to food is one of the most important of it. And if directly or indirectly I deny or deprive your right to food somewhere, like I am also like be a party to prevent access to justice, which is being guaranteed through the legal system of this country. But nevertheless, like I'll not go in detail, but I would like to give some dimensions and some idea with respect to this particular topic upon which I am going to speak about. See, the first thing what we need to understand here is, much has been spoken about access to justice, its dimensions, everything. The thing is, it's a constitutional mandate. What does it mean? What happens when Constitution enunciates it, enumerates it, or makes it a directive and says that this access to justice needs to be provided? See, when it becomes a constitutional mandate, the kind of status it derives in a legal system is very, very important, because Constitution is a supreme law of the land, and it is supreme because it is meta-legal. There is nothing to test the validity of the Constitution, and all organs and all levels of government derive its powers and has to act in accordance with the Constitution, and this Constitution mandates that there should be access to justice. And when we understand this particular concept, access to justice, what we need to understand, like supremacy. First of all, a constitutional mandate to prevail in a legal system, constitution should be a supreme. Unless there is a supremacy of the constitution, constitutional mandate will not have any sanctity. So that supremacy of the constitution is ensured through various factors like judicial review, and you need to have an access to justice. If there is no access to justice, you cannot ensure supremacy of the constitution also. And the very purpose why a country's draft constitution, ಯಾಕೆ ಸಂವಿಧಾನನ ರಚಿಸ್ಕೊಳ್ತಾರೆ ಒಂದು ಕಾನೂನಿನ ಚೌಕಟ್ಟಲ್ಲಿ ಒಂದು ರಾಷ್ಟ್ರದಲ್ಲಿ? See, basically there are so many reasons, so many purposes why do we need constitution. Two important things is organization of sovereignty and organization of civil liberty. The sovereign power needs to be organized through constitution. Power corrupts and absolute power corrupts absolutely, but a constitutional law power person says that power controls power. And the power is being polarized, structurized, and the power centers are pitted against each other in order to ensure constitutional compliance. And what is important is a constitutionalism which has to prevail in a legal system. It is not sufficient that there is a constitution. And how do we impose limitation on the exercise of power by state? The exercise of power by state is limited by entrenching civil liberty into the constitution. What is the consequence? The moment when civil liberty is entrenched into a constitution, that civil liberty acts as a restraint on the exercise of power by the state. So, for example, Part 3 of the Constitution, where you come across fundamental rights, and any law which is inconsistent with Part 3 becomes void. So this Part 3 acts as a limitation on the exercise of power by the state, and every constitution tries to strike a balance between sovereignty and liberty in a legal system. If there is absolute sovereignty, that leads to despotic rule. If there is absolute liberty, that leads to anarchy. And how to ensure this balance, how to put a limitation on the exercise of power by state is by entrenching a civil liberty to it. And it is not sufficient that you have added a chapter in your constitution which secures certain rights. What is more important is, like you have studied ubi jus ibi remedium. A right without remedy is a meaningless. It is reduced to a status of nullity, mirror image. Now, it is not sufficient you secure the liberty, but you should also provide a means to avail that remedy. There should be a procedural flexibility to avail that remedy. There should be an effective mechanism to enforce the rights which is being guaranteed. That is where access to justice comes into picture. If access to justice is denied, then that will hit on the constitutionalism itself, wherein the state turns out to be an autocratic institution which can violate the rights of people. That cannot happen when there is an effective access to justice system which is at place in a legal system. That is where access to justice, and that too it is a constitutional mandate. When we look into this access to justice and its journey over a period of time, many authors have given different dimensions and it has developed in different phases over a period of time. From the time Constitution has came into picture till date, there are so many developments which have taken place. At one point of time, we started viewing it from the point of view of providing a legal aid. So they were telling equal justice, equal opportunity, you need to give a legal representation, legal aid. And from legal aid, it was realized it is not sufficient to make this access to justice meaningful only by providing a legal aid. We have to carry forward, we have to go ahead, move ahead. Then we thought of like reducing or liberalizing locus standi, mitigating the harshness of this procedural rigidity. And from legal aid, we moved on towards providing a liberalized locus standi approach, wherein non-state actors started playing an active role in strengthening access to justice, in providing access to justice. And we have come across liberalization of locus standi, public interest litigation, and public interest litigation has played a vital role in ensuring access to justice. And here I have made it very clear that access to justice should be understood in a broader sense. It should not be confined only to a dispute resolution mechanism through courts. access to justice has wide connotations, and much has been discussed through various technical sessions. See, when I say access to justice, it should not be viewed only from the individual's point of view of enforcing his fundamental right or a statutory right which is being guaranteed through a statute. When the structurization of power takes place through constitution, and when there is any exercise of power which is not in accordance with the constitution, you have an access to justice. And India being a federal country, the power is being distributed between center and state. And when there is an exercise of power which is not being ordained in the constitution, if it is exercised by the center, if it is specifically given to a state autonomy, states have an access to justice. And when state interferes into a domain of a center, center is having an access to justice. Access to justice should not be confined only from the point of view of getting your fundamental rights enforced or a statutory rights enforced. Access to justice is such a wide concept, and ultimate goal of providing access to justice is realization of a constitutional goal as enshrined in the preamble. This access to justice should lead to realization of justice, social, economic, political. And if you read R.C. Lote preamble, the spirit and backbone of Indian Constitution, you will understand why it is justice, social, economic, political. Why not the other way around? And the end result, if you fail to ensure an effective mechanism to provide access to justice, is the constitutional goal gets defeated. You will not be in a position to realize justice, social, economic, or political. So, more importantly, here we will be focusing from the point of view of an individual when his right is being violated, and there should be an access to justice which needs to be provided. And at the outset itself, one more thing what needs to be made very clear is access to justice is different from that of access to courts. Justice is not confined only to the courts. Courts is one formal mechanism to redress the grievances. But besides court, there is an institutional mechanism, and there are so many mechanisms which also has a constitutional basis which provides justice. And justice should not be confined formally from the point of view of accessing to the courts. There are so many things. If you look into a Panchayat justice, an article written by Upendra Bakshi, he says that how Panchayats provides justice. And much of the literature focus upon the role of legislature in ensuring access to justice by passing National Legal Service Authority Act or bringing an amendment to the Constitution, or the interpretation given by the judiciary. And just Maruti sir was referring that international obligations 253, Article 41, and when you look into even UDHR, Article 8, Article 10, all these things speak about access to justice. But it should not be confined only to the judicial platform. Now, when you look into this, access to justice, it is a duty of a state to ensure access to justice. It is one of the duty. State has to promote welfare, state has to protect the interest of weaker sections, state has to protect the property rights of an individual, and it has to ensure access to justice. I was telling, we focus upon judicial interpretation given to Article 14, 21, 32, so on, so forth, and legislations which have been passed. But executive plays an equal important role in ensuring access to justice. When there is a grievance, when there is a rights which have been secured, from village accountant to Panchayat development officer to Tashildar to AC to DC, everybody is playing an important role in ensuring access to justice. When there is a flood situation, people first will go and knock the doors of Panchayat. They will not go to a court of law. And the Panchayats have been entrusted with the functions under Panchayat Raj Act 2013. And if you look into section 58 of Panchayat Raj Act, you will come across how by performing functions, Panchayats strengthen, promote this access to justice. And especially with regard to land matters, revenue matters, the matter will go to a court when he is not in a position to avail the remedy through Panchayat or through Tashildar or through AC or DC, and they also act as an appellate authority. in redressing the grievances which are faced by the public. In addition to the role played by the executive, ADR mechanism itself has come into existence, which has a statutory basis. We have any number of legislations which also provides for mediation, conciliation, arbitration. So access to justice should be viewed from a very broader perspective. It should not be confined only to an individual point of view or not from the point of view of court, what it provides as a justice. See, access to justice encompasses all elements which are needed to enable a citizen to get his grievance regressed. Now, when we move further, like there are so many elements of access to justice, or what you call it as an elements or components of access to justice, and it is only illustrative, it is not exhaustive. There are so many things. And when I say justice, it protects an individual liberty and it also tries to balance individual liberty with that of community interest. When providing justice, you will not focus only from an individual point of view. Individual liberty needs to be protected. At the same time, community interest should also be taken into consideration. There is a need to strike a balance between individual right with that of community interest. Otherwise, it leads to injustice. And justice has so many connotations: corrective justice, distributive justice, so many dimensions are there. And all these are like elements of access to justice. And all these elements finds its place in a statute, or it has a constitutional basis, or judiciary has interpreted and included this as an integral part of 14, 21, 32. So accessibility. If you look into a research report which is made by the Supreme Court itself, like it is a report wherein we come across that it very clearly says that at least there should be a provision which should be made, which very Center for Research and Planning, Supreme Court of India, Report on Access to Justice 2016. It is a report submitted by Center for Research and Planning, Supreme Court of India. It says that access to justice is meaningful when each citizen has a ready access to court, and this will be possible only if the number of courts is increased. And the same report says, like, you should provide justice within 50 kilometers radius, and a person should not be in a position to travel more than a half day to reach a justice. This is what the Supreme Court says. And access to justice cannot be discussed in 15 minutes or 20 minutes. It is discussed from cost-benefit analysis. What is the cost which is involved to provide a legal aid? What is the cost which is involved to create legal awareness? And what is the benefit which the society is going to derive by providing an access to justice to the victim or a deprived? In a criminal cases, if you are not going to provide an appropriate remedy, provide him an access to justice, then that would have impact on society. So this cost-benefit analysis, and it is also measured in terms of demand supply. What is a demand? There is an infinite demand for legal service, but there is a finite supply. And the United Nations General Assembly 2020, 11th session of United Nations General Assembly 2020 discussion paper says 1.5 billion people cannot obtain justice for civil, administrative, criminal justice problems. And United Nations General Assembly makes it very clear, somewhere with all these legislations, with all this ADR mechanism, with legal aids, with lok adalats, we have failed to ensure this justice. And when you are not in a position to achieve access to justice, justice, social, economic, political, invariably gets defeated. And accessibility is very awareness. Most of them are not aware only that they have rights, and where will they go to get it enforced? And even legal assistance, it is not only about assistance, the kind of, when you say equal opportunity, what is the kind of assistance which is being provided? Whether it is equally effective to counter the other party, or it is only for the namesake you are providing a legal assistance. And equal opportunity, affordability. Affordability is also considered to be an integral part of Article 21 of the Constitution, where if you, because of your economic reasons, if you are not in a position to go to court of law, that itself defeats the purpose of access to justice. And effective, how effective is this legal aid provided, legal assistance provided? How effective is this access to justice mechanisms which is at place in India? We need to think. Competence, impartiality, and corruption-free. The justice delivery system should be corruption-free, and it should also be expeditious. Speedy trial is an integral part of access to justice. And see, there are so many constitutional provisions which the court has interpreted all these provisions in order to promote, strengthen this access to justice. And I need not go on each and every article to explain because of paucity of time. Some of the, I think this keypad is not working. Yeah. So if you look into, this is not functioning. Keypad is not working. Go to the preview arrow. No, it's not working. Go to the next slide. See, if you look into, these are the cases where you come across judiciary has recognized this particular thing, and Ramakant versus State of Madhya Pradesh, right to access to justice flows from Article 21 and 22 to the Constitution. And the courts have developed what we call it as a doctrine of implied fundamental rights. Justice Matthew says, Part 3 is an empty pot. Generation pour wisdom into it. So, fundamental right doesn't mean what is being expressly provided in Part 3. There are many more things which have been added to Part 3, and this is what we come across. And Anita Kushwaha versus Pushpa Sadan, affordability of legal process is an integral part of right to access to justice. Next, move on to the next. So, legal aid is considered to be an integral part of 21, 22 of the Constitution, and state to provide legal aid. Otherwise, because of economic disability, if a person is not in a position to go to a court of law or any mechanism to get his rights redressed, his grievance redressed, that would defeat the very constitutional goal itself. And this is a very important decision given by the Supreme Court, where it very clearly says that if there is any dereliction by the magistrate in not making aware that you have a free legal aid, you have a free legal representation, that would be considered as a dereliction of duty and would make the magistrate concerned liable to departmental proceedings. So that is the duty which is imposed upon the magistrate, to make them aware that you have a legal representation. Move on to the next slide. So again, speedy trial is an integral part of access to justice, and speedy trial, access to justice are antinomies. On the one hand, access to justice, you open the floodgates, you allow the people to come and file the cases. On the other hand, you want speedy trial. The speedy trial and access to justice, they are antinomies. You have opened the floodgates, you have liberalized locus standi, you have developed epistolary jurisdiction. You say writing a postcard, it can be converted into writ petition. But on the other hand, when the number of cases comes, what is a judge-case ratio? And the speedy trial, when you open the doors for access to justice, it is very, very difficult to ensure speedy trial unless and until there is an infrastructure and the number of judges, the number of courts. So all these things are very, very important. Move on to the next. See, this is a very, very important aspect, and if you look into most of the books, articles, what is being written, and when you look at it from a constitutional dimension, they focus on Article 39A. They say Article 39A has been inserted through 42nd Amendment, and which promotes justice, you need to provide justice, and all those things. But most of the literature doesn't mention correspondingly. While they were inserting Article 39A, correspondingly they inserted this Article 323A and 323B. 323A provides for constitution of administrative tribunals. 323B provides for constitution of tribunals for other related matters. For example, Income Tax Appellate Tribunal, National Green Tribunal. On the one hand, they insert Article 39A and says that you should secure access to justice. On the other hand, they also provide a platform wherein other than courts, certain judicial, quasi-judicial bodies, tribunals, they can also provide a platform for ensuring for access to justice. And administration of justice, which was found in entry 3 of list 2, got shifted to concurrent list from state list. This is the major move wherein the central government was given more importance and vested or entrusted with the duty to ensure access to justice. The moment when you are shifting administration of justice from list 2 to list 3, and any law, when there is inconsistency, the central law will prevail. This is the aspect which very clearly says that the constitutional commitment towards ensuring access to justice by imposing a duty, mandate. So you can derive mandate of the constitution from various provisions, and unfortunately much of the literature doesn't focus upon this 323A and 323B, and you will not be in a position to understand access to justice and constitutional mandate unless you look into the judicial approach towards interrelationship between part 3 and part 4 of the constitution. If you want to understand access to justice and its development over a period of time in India, you should look into how the judiciary has adopted its approach towards interrelationship between part 3 and part 4 of the constitution. Chandra Bhavan boarding, very clearly we have said balance between part 3 and part 4 is a bedrock of the constitutional jurisprudence, so on and so forth. We will never be in a position to understand these things. And it's not only about legal aid, it's not only about public interest litigation, it's not only about the tribunals, fast track courts, special courts. It is also about integration of ICT in promoting access to justice. Niti Aayog very specifically says that ICT should be integrated to promote access to justice in India. And Niti Aayog is a think tank of India, which says that information and communication technology should be integrated to promote access to justice in India. And if you closely look into Article 39A of the Constitution, it provides 3 ways through which you can promote justice, through which you can ensure equal justice, equal opportunity. One is through legislation, the second is through schemes, and the third one is through any other ways. If you look into in India, all these 3 modes which have been specifically mentioned in Article 39A has been given effect to through different approaches which have been adopted in India. Legislation, we have any number of legislations. If you look into National Legal Service Authorities Act, that is a basis for legal aid and legal awareness and Lok Adalat. And even if you look into Gram Nyayalaya Act, there are so many Gram Nyayalayas which are functioning in India. And Gram Nyayalaya Act is such an initiative taken by the government in order to provide access to justice. And BNSS, which also contains a specific provision to provide legal representation. In addition to this, we have Arbitration and Conciliation Act, Mediation Act 2023. Any number of legislations are there. And 39A says that you promote justice through legislations. Any number of legislations are there. And even much before all these developments, if you look into Hindu law, if you look into Industrial Disputes Act, it is inherently present. The methods, mode of dispute resolution, you can go to conciliation, you can go to mediation further. See, the second part of 39A, which says the schemes, adopts, this is where executive comes into picture. Like adopting schemes, funding for this particular schemes, constituting authorities, issuing circulars, executive has played a, and this is specifically relating to Department of Justice, Government of India. The scheme in order to strengthen, promote access to justice, it is what we call it as DISHA. And designing innovative solution for holistic access to justice in India. A holistic access to justice in India should be provided. And this DISHA includes in itself what we call it as Tele-Law. And it is there is a mobile app also called Tele-Law. And there is a helpline number 14454. You can call. You will get a reply, pre-litigative process, what remedy you have, how you can avail a remedy, how you can get a remedy when the rights are being violated, and through Tele-Law, reaching the unreached. That is what is a tagline of Department of Justice, and it says As on 31st July 2025, the total number of cases registered was 1,13,20,966 and the total advice given was 11,79,560. This is where we are integrating information and communication technology to ensure access to justice in India. Department of Justice, Government of India, with this ICT wing, it has done this. And this is an e-interface platform that aims to empower people through pre-litigation advice. You can go, you will get the statistics in Department of Justice website. Next slide, please. See, Nyaya Bandhu, this is a scheme of Department of Justice. Nyaya Mitra, legal literacy, legal awareness. E-Courts Mission Mode Project 2025 has already come into picture. And since October 2019, Department of Justice is implementing a centrally sponsored scheme with regard to redressal of grievances, especially relating to the sexual offences. Move on to the next slide. NALSA, it has so many schemes to ensure access to justice. It is not only about who is entitled under Section 12, and there are specific approach adopted through NALSA for disaster. Whenever there is natural disaster, you have a legal service, you have access to legal service. Victims of trafficking, workers, unorganized sector, children. Next slide. For disabled, mentally illness, senior citizens, and victims of acid attack, for all these people, there is a specific scheme through NALSA which provides access to justice. Move on to the next slide. Jagriti is one such particular scheme. In 2025, it has come into existence to spread legal awareness, to provide access to justice. And Samvad, just now in the previous presentation, we were looking into how tribal rights are being protected, how justice is being ensured to them. Strengthening access to justice for marginalized, vulnerable Adivasis and denotified nomadic tribe scheme 2025. This is what we are doing just if you look into 2025, the efforts which are made by the institutions of governance to ensure access to justice is tremendous. And Legal Aid Contact, National Helpline, there is a number. Women Helpline, there is a number. This is all platforms which ensures access to justice. Move on to the next slide, please. And 323A, 323B, already have spoken with regard to this particular thing. Next slide, please. So to conclude, and time is the essence of contract, in contract law. And I have seen the time, and I am left with 3 minutes to wind up my presentation to the designated time, and that is what is very important. And to conclude this presentation, this is not an end, this is a beginning, and you take forward the dimensions which have been thrown open to the floor. And see, when you look into conclusion, all organs of the government, what we call it as institutions of governance, they are functioning in furtherance of realization of constitutional goal, that is access to justice. And ADR and PIL, public interest litigation and ADR, they are very efficacious in strengthening justice, in ensuring access to justice. You come across benefits of ADR, expertise, knowledge, quick disposal, and it harmonizes the relation between parties. In court, you will only get remedy. Professor B.S. Patil sir is there. He is a renowned scholar in the area of this ADR, negotiation, client counseling. And we come across, it is not only the remedy in terms of justice, it harmonizes the relationship between parties. That is ADR. And like public interest litigation. Public interest litigation, as I said, it has paved the way for non-state actors to play an active role. Here you need to be very careful. Liberalization of locus standi is done in terms of enforcing your fundamental right, but whenever there is center-state relations which gets affected, locus standi doesn't get liberalized there. You cannot, the individual cannot go and say, unless there is something which affects the fundamental right which is being guaranteed. And access to justice is vital to functioning of democracy and rule of law. Both happens to be a basic structure, and in a way, you can draw an analogy. This access to justice is a basic structure of the Constitution. There is no doubt, undoubtedly, unequivocally, you can arrive at a conclusion that this access to justice is a basic structure of the Constitution, and it is the access to justice which is a bedrock to ensure constitutional governance. If there is no access to justice, constitutional governance gets defeated. And finally, constitutionalism. In simple words, I say constitutionalism means limitation on the exercise of power. Constitutionalism and arbitrariness are antithetical to each other. In a legal system where there is arbitrariness, there is no constitutionalism. And constitutionalism can be ensured through this access to justice if there is no mechanism to get your rights enforced, get your grievances reduced. Then the state will turn out to be an autocratic institution which denies, deprives, and it will contravene the parameters of the constitution. And the constitutionalism is surviving in India because of access to justice. The mechanism which is at place, if it is effective, that strengthens constitutionalism. Otherwise, it weakens constitutionalism. And finally, like what I would wish to say is, unless there is access to justice, which is ensured, the constitutional goal as enshrined in preamble, that is justice, social, economic, political, would turn out to be a mirror image, and we will not be in a position to realize it. But if you provide an effective mechanism to ensure it, promote it, definitely we can march towards realizing this constitutional goal of realizing justice, social, economic, and political. Thank you, one and all. And if there are any questions, I would be very happy to answer.
Thank you, sir, for your enlightening session on the constitutional mandate to access to justice. We will now move on to the interaction segment. If anyone has any questions, you may kindly ask now. Okay, since there are no questions, let us proceed to the next part, that is vote of thanks. On behalf of Kilper, Bangalore and Vaikunta Balika College of Law, Udupi, I extend a heartfelt gratitude to Dr. K.C. Girish, Assistant Professor, KSLU Hubballi, for your valuable insights, thought-provoking session. Thank you, sir. On behalf of Kilper and VBCL Udupi, we present the memento as a token of appreciation.
I would be failing in my duty if I were not to acknowledge the dimensions which I have developed. I used to cross-verify with my teachers, and I acknowledge the discussion what I had done with my guru, Professor P. Ishwar Bhatt and Professor M.R.K. Prasad, Puneet from Delhi, and so many we have discussed. And most of the times, like I myself used to get doubts, am I going in a right track? So I acknowledge their time and the valuable inputs. Like the creative idea was mine, but I wanted to get it verified whether I am going in a right direction. So I thank all those who have helped me to formulate, and none other than Professor C.S. Patil, sir. Every day, you will not believe, at least 5 hours of discussion must have taken place between me and C.S. Patil, sir, only with regard to this topic. Inaugural session alli heltidralla. Avun hange, sometimes he irritates and he makes us read. He comes with so many questions and ಹೇಳೋದು ಹೇಳ್ಬಿಡ್ತಾನೆ, ಹೋಗ್ಬಿಡ್ತಾನೆ, ಉತ್ತರ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ನನ್ನ ಮನಸ್ಸಿಗೆ ಕೊರಿತಾ ಇರುತ್ತೆ, ಮತ್ತೆ ನಾನೇನಾದರೂ ಹುಡುಕ್ಬೇಕಂತೇಳಿ. So I acknowledge his contribution, and he has played a very crucial role in molding this particular ideas. Thank you.
Thank you, sir. Thank you, everyone.
We extend a heartfelt gratitude to all our distinguished speakers for sharing their valuable insights. Your contributions have made this seminar truly enriching and thought-provoking. With this, we come to the end of all technical sessions. Participants, kindly note that offline paper presenters are requested to assemble in their respective classrooms immediately after lunch. I request everyone to proceed for lunch. We will reconvene for paper presentation and valedictory session as per the schedule. Thank you all once again for your active participation and gracious presence.